Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifted. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. I'm back. It is Pam Esquire, also known as Your Law Intellect. We have a doozy to talk about on today. I know that many of you guys wanted me to talk about that motion to dismiss, and we're going to get to it, okay? But before I could even get to it today, Wooten has filed on behalf of the state a response to the supplemental information that the court asked. What am I talking about? I am talking about Ernest Williams, who is the ex-husband of Shirley Strawberry, who is one of the co-hosts on the Steve Harvey Morning Show. And Wooten has attached so many exhibits and information that I don't even know what to say. I don't even know what to say. Okay, we're going to start out with Ernest Williams is innocent until proven guilty in the court of law beyond a reasonable doubt. But what I will say is that one of the things that I told you all is that based on how we filed it and the information that we have, the state of Georgia has independent information against him that has nothing to do with this vehicle search. So one of the things I told you all is I agree with the state from that perspective because we did Freedom of Information Act requests where we seen incident reports, where we seen different the actual arrest warrants and what they were based on, that I knew for this specific case, some of the things that they were alleging was going to be a problem to overcome. Well, what Wooten has done in this filing, and literally, I want to say I pay over $100 for these documents. Okay. So because of that, thank you guys so much for coming in with the super chats. Thank you so much, Jennifer. I appreciate that because these documents were not cheap. Thank you again, Lady Ella, for the super sticker. I appreciate that as well. And I'm sure this isn't their whole case. But Wooten definitely let everybody know that he has independent evidence outside of whatever was found in that truck. So before we get started, make sure you hit that like button. I don't even think I introduced myself, did I? I'm Pam Esquire, also known as Your Law Intellect. Make sure you hit that like button on the way in and subscribe to the channel if you have not done so already. Thank you so much for all of your continued support. Thank you so much, Miss J, for the super sticker. I appreciate that. Now, for those of you that don't know, the last recording that I have of a hearing was because there was a motion to suppress the evidence that was found in the vehicle search. Okay. When we got to the end of the video, we knew the court was leaning towards that the search was an unlawful search. The court was leaning towards that. I still said it was going to be a problem because I knew that they had independent information. Well, what the court did was say, hey, what I need you to do is file a supplement on what specific information are you saying should be suppressed that is related to this case, related to these, this indictment. So Hoover, who is Mr. Williams' attorney, filed a supplement. But when he filed that supplement, y'all, he did it under seal. Like, I didn't understand it because it was just like, okay, I don't remember there being some notice or something like that you guys can do it under seal, because they didn't want us to see it. Okay. And it seemed like it was a problem to me, but they basically said, if you're not the attorney of record, then you can't get the document. Because I sure was asking, like, is this a mistake? Because I don't see any orders of anything being under seal. They was like, ma'am, you can't get it unless you are an attorney on the case. Respectfully, have a great day. Kick rocks. So we didn't see it. Well, what happened is Wooten, or the state, they filed a motion to dismiss. In that motion to dismiss, they attached what the supplement was as an exhibit. We didn't go over the motion to dismiss, you guys, I know. But they did attach that. And basically the state said it was under seal, but there was no reasoning for it to be under seal because we're not under order. So they attached it to let us know what was in there. So the first thing we are going to do, after I thank everybody for these here super chats, thank you so much, is we are going to go over what the supplement was and then the state's response to the supplement, because that's what we're talking about now. Again, separate and apart, the state has filed a motion to dismiss. They're saying that basically Ernest Williams has no standing. It wasn't his truck, no way. And he got it through fraud because he was married for fraud. That was basically the gist of that motion that we didn't go over. But at the issue and the motion at hand, what happened is, again, Williams filed a supplement as directed by the court. And they didn't have that on the docket. Well, Wooten in his motion to dismiss did attach that. So now we can go and see what the supplement was. And now we're going to be here for a little while for the state's response, because the state response was way more thorough than what that supplement was. Okay, from Ernest Williams. All right. Thank you so much for being a member for 10 months, BT Delight. I appreciate that. Thank you for gifting a members only me 23. Miss Lady, thank you so much for the super sticker. Lamario said both the defense and the state must know the evidence, correct? Yes. You have to turn over there. We're not an ambush system. And so there's no Matlock surprises. You're supposed to know. Now, sometimes they will withhold it to the day before, or they'll have like phone calls or something, but those are all over the internet. They'll have phone calls or something and they'll try to spring it on you, hoping probably that you don't have time to listen to it. But yeah, for the most part, and especially what we call Brady material, which is exculpatory evidence, favorable to the defense, yes, you have to turn what they have. I'm supposed to have what they use. I should have been able to see it so that I know how to defend against it, and vice versa. The Real Empress, thank you so much for the super sticker. The favorite one, thank you for being a member for 8 months. You said right on time. You asked for my Cash App. That is in the chat. I'm sure one of the mods probably put it in there. Thank you so much in advance if you send me a Cash App. I got to bring my phone down here so I can see everything if you guys do send one. Miss M. Kenny, thank you so much for the super chat. You said that 10% back for the documents. Them documents, they was like, this is your tab. But then when I seen everything that was attached, I could literally probably break some of that down and do separate shows on some of the stuff that was attached. And we may do that. We don't know, because we may not have enough time to get through all of that. So for real and true, thank you for the super sticker. Thank you, Shorty, Miss J. I think, did I get all of them? Glorious Love, thank you for being a member. Tam, I love you here. Thank you so much. Thank you. Thank you guys so much again for all of the love and the support. All right. So keep hitting that like button and subscribe to the channel. Let me pull this first. Listen, we ain't got time to be tarrying because we got a lot going on here. Let me see. So did I save this on here? Okay. I don't know why my StreamYard won't let me pull it up like this, but we're going to make it do what it does. Okay. That's the motion to dismiss. But what is this one? I don't know. I don't know why this is doing this. Let me see if it comes up if I share it or if it's just not going to show. Oh, it did show up. All right. So this was the brief, I guess, that we wasn't supposed to see that was attached. All right. So now comes defendant Ernest Williams buying through the undersigned counsel and hereby files the supplemental brief to suppress vehicle search and all derivative evidence. So what he's trying to do is he's saying that if you suppress the vehicle, then anything that you received from even the evidence, like say for instance, in the vehicle, you find a phone number. You call that phone number and that person says, Ernest Williams did A, B, C, D, and E. That's considered fruit of the poisonous tree because but for that search that was unlawful, you wouldn't have got that information. So they're trying to get as much information suppressed as they can, which a great attorney should do. And so this was after the hearing. Again, we can tell that the judge was definitely leaning towards Mr. Williams. But the judge said, well, I'm going to need a supplement because you haven't said exactly what information you're saying is fruit of the poisonous tree. So this was the actual supplement that the court asked. So it's to suppress the vehicle search and all derivative evidence obtained from the search of the white Ford F-350 that we know was registered to Shirley Strawberry, and all derivative evidence pursuant to the 4th, 5th, 14th amendments to the Constitution of the United States, Article 1, Section 1, Paragraph 1, due process, Paragraph 13, related to search and seizure, Paragraph 16, self-incrimination of the Constitution of the state. Filed a motion to suppress on September 30th, 2024, challenging the search of his vehicle upon his arrest. The court held a motion hearing on December 18, 2024. Y'all check out that video if you didn't see it, where arguments from Mr. Williams and the state were presented. At the end of said hearing, the court ordered Mr. Williams to file a brief outlining which pieces of evidence he believed were derived from said search and should be suppressed. If the court were to agree the search itself was in fact illegal. In support of this brief, Mr. Williams shows as follows. Mr. Williams was arrested on July 7th of 2022. So yes, he has been in jail in Cobb County for 2.5 years, going on 3 years in July, at approximately 1:30 by Patrol Officer Fields and Officer Big Word. I don't know. I'm going to mess that name up, but y'all see it with the Y. The vehicle Mr. Williams was driving at the time was subsequently illegally impounded and illegally searched the following day. So what they're doing now is going over the different people, and these people were actually mentioned in the indictment as part of the indictment. Ms. Gretchen investigation. During the search of the Ford F-350 on July 8, 2022, a backpack was found inside the vehicle. Within the backpack, a piece of paper with Melody Gretchen's credit card number was located. Ms. Gretchen authorized use of the credit cards for the purchase of home appliances. After finding this piece of paper, Patrol Officer Fields reached out to Ms. Gretchen via a phone call at approximately August 15, 2022, almost a month after Mr. Williams was arrested. So they're saying their connection with Melody Gretchen was because of the credit card numbers they found and that they reached out to her via phone, which I figured. I think I said that was probably going to be one of the ones they tried to say was connected to this vehicle. Ms. Gretchen stated she reported her car stolen on June 4, 2022 with the South Fulton Police Department. Ms. Gretchen also mentioned a report she filed regarding the use of her credit card for items not authorized. Ms. Gretchen was interviewed again on August 30th of 2022 by Detective Gooden and Parole Officer Fields. They're being real specific to call her a patrol officer, because remember she got promoted, I guess, to detective during the course of all of this. During this interview, Ms. Gretchen provided information on how she met Williams, how the two of them discussed doing business together, and what steps the two of them took towards their business venture. Following this interview, Ms. Gretchen then filed a report against Mr. Williams for using her credit card for unauthorized items. So the next person they talk about is Ms. Bickham. During the search of the F-350 on the 8th, a backpack was found inside the vehicle. Within the backpack, there was a check from Wade Ford for $28.52. It was located along with invoices from the sale of a 2021 Mercedes-Benz G-Wagons. Remember, I believe that was her vehicle. Miss Bickham was interviewed by Detective Gooden and Patrol Officer Fields on October 13, 2022. During this interview, she discussed how she and Mr. Williams met, as well as their multiple business discussion ventures. Miss Washington was interviewed on August 27th of 2022. During this interview, she talked about a 2021 Harley Davidson that had previously been seized. She further discussed how Mr. Williams helped her pay the down payment on the motorcycle, how they worked together on other business ventures, and how she didn't know he was already arrested when she was trying to get in touch with him. So these must be from like the interview sheets that the defense has. Miss Delaney was interviewed by Detective Gooden and Patrol Officer Fields on September 15th of 2022. Patrol Officer Fields identified Miss Delaney as a previous associate of Mr. Williams after they searched the residence at 980 Pine Grove Road and located the 2020 Harley Davidson motorcycle. During the interview, Ms. Delaney explained how she met Mr. Williams through another person and how they discussed possible business ventures. Ms. Delaney also explained how she wrecked another vehicle she had and gave Mr. Williams permission to store her Harley Davidson and trailer at his residence. Sometime later, Ms. Delaney filed a report with Sandy Springs PD and applied for a warrant hearing in Fulton Magistrate Court. The warrant application was denied. That's the one I showed you guys where he actually had Erica King represent him as April Holloway. And I was like, she was winning some of that stuff. This was one of the ones. Miss Delaney had filed a report and she tried to get a warrant, which the court denied. And Miss Delaney was ultimately charged with filing a false. Oh, I didn't know that. And Miss Delaney, they charged her with filing a false police report. Oh, wow. Miss Delaney was again interviewed by Patrol Officer Fields on September 16, 2022. This interview was specifically in regard to Patrol Officer Fields getting information for the theft of the Harley Davidson. Afterwards, Mr. Williams was charged with multiple counts of conspiracy to commit a felony. So they're talking about all the evidence seized from the Ford F-150, F-350. It was a black book bag with multiple documents. The Vista Ray eviction stuff that we went over. There was a Wells Fargo letter dated April 15th. There was an affidavit of garnishment on a financial institution, receipt for precinct 1 autos, paper with Melody Scretchen's credit card number, the checks from Wade Ford connected with Gail Bickham, an invoice from the G-Wagon sale, multiple hotel invoices, notice of payment from Palmer Dodge, and they're putting like the charges they're connected to. So charges count 24 to 25 for the Palmer Dodge, deposit account fraud, theft of services. So the actual warrants were in there as well in the backpack. Atlanta Fine Cars buyer contract. Goodness, he had a lot in this backpack. The Bentley purchased March 2020 plate, silver and black, that G-Tech computer relating to the case number with the, with the chronology. Look like it's some other cases. He has the paperwork in there. There were 3 iPhones, 1 black iPhone found in his person, 1 black iPhone in a black bag, and 1 gold iPhone found in the truck. Then it looks like it's some more. This was the case numbers related to those. It looks like in front of Judge Sandra Witherspoon. There was another gold iPhone. Text messages from the phone were downloaded between Ernest and Dominique. about another alleged victim. iCloud with Instagram search warrants, 2 scan discs, keys to multiple vehicles, 2 storage unit keys. Good gosh, 2 black adult toys, black mask with zips, and the liquid V. So we knew all about that when we read the incident report. And then it got a summary of payments. So they're saying the subsequent warrants issued based off of the searches, the theft by deception, the financial transaction card fraud, and it has the individual case numbers. The 990 Pine Grove, 10 total phones, and one of those belonged to Erica King's husband, 3 iPhones belonging to Erica King, black, white, and white, a Samsung phone for the master bathroom, OnePlus phone for a master bathroom, 3 TCL phones, a silver iPad, a MacBook Air, an Apple desktop, a HP desktop, checkbooks, Fendi wallet, legal stamps, vehicles, a Rolls-Royce Ghost 2011 white, a Cadillac Escalade silver, 2 keys, a Honda key, a Rolls-Royce key, box of money, and then it says fake money in parens, 4 notebooks, Georgia driver's licenses. Oh goodness, y'all, it's a lot. IRS notification of the EIN. Oh my. There's a Bentley, 2014 Bentley. This was from 980 Pine Grove, so it gives you the case number. The Bentley, the black Harley Davidson, that's registered to Regina Delaney. Oh my goodness. So then it's going through all of the different counts and saying what was allegedly attached to the accounts. So then they go on to say, yeah, let me make sure y'all are right over here in this. So yeah, it's a lot going on. So some of this stuff, it sounds like it was a lot in the backpack, but because of that, warrants were issued. So because of what they found in the backpack, it gave them probable cause to get warrants to search cars, houses, whatever else stuff. So no, all of this obviously was not in the backpack or in the truck, but it was a lot in the backpack, they're saying, that led them to be able to have probable cause to get these warrants to go into the residences and all of that. So this is how the fruit of the poisonous tree works. If you got information and it's my name and that's it, and then from that you say, well, let me do a background check on Pam, and then once I do that, I say, well, let me go see if she got a criminal background. Okay, from that, okay, let me go see if there's any warrants for her arrest. Okay, from that, I'm gonna do a whole billboard. Has anybody been scammed by Pam Esquire? And you know what it's like the repetitiveness. So what they're trying to do is connect that all of their information somehow is connected to this one search. But like I told you guys before, there was independent information because you had people that were going to the police and filing reports. So that's why I was saying with this one, I don't know how they're going to open. Now, as far as if that's the only connection they have to those pictures, that may be a problem. But it looks like the state is filing that motion to dismiss to say he can't even challenge the search at all, which may potentially even save those claims that they have, those allegations they have against them. Okay. You said okay, because I was about to say. So we got that straight, all right? So basically what I'm going over is what we didn't have before until Wooten filed the motion to dismiss, which is the supplemental brief that the court asked to tell me, hey, okay, I'm leaning towards that this search was unlawful because I'm still not understanding why it was impounded in the first place and why it was a search and all of that. So assuming that I am going to rule in your favor, I need a supplemental brief because you haven't told me what all is fruit of the poisonous tree. And his attorney kept saying everything. Wooten kept saying, we don't even need a hearing because I probably don't need none of this stuff anyway, because I have independent information, or what we call inevitable discovery, meaning I would have found it anyways. So I may not need it anyway. But of course, his attorney, being being a good defense attorney, was like, no, I think everything should be suppressed. And so what he's doing in this supplemental brief is he's trying to connect the dots and say, okay, you got Scretchen's number. You didn't interview her for a month. She told you that she filed a police report and all of that. Otherwise, you wouldn't have known about the police report. Like, they're trying to connect everything to everything you found in this truck is how you found out about a lot of this stuff that's being alleged against Mr. Williams. So that's what they're doing with this. This is the supplemental report that the judge asked for. So they go on to tell you about the purpose of the exclusionary rule is to deter future unlawful police conduct and thereby effectuate the guarantee of the Fourth Amendment against unreasonable searches and seizures. When evidence is obtained in violation of the Fourth Amendment, the judicially developed exclusionary rule usually precludes its use in a criminal proceeding against the victim of the illegal search and seizure. The state has failed to adduce evidence in their response to the defense motion to suppress, as well as through testimony at the hearing, sufficient to establish the predicates for the application of any exceptions. Georgia courts generally view the impoundment of a legally parked vehicle as unreasonable unless there is a specific justification for the vehicle to be impounded. So, if you guys recall the hearing, what Detective Fields was saying was basically they showed video, I guess, or they did show video of which he was like, can I call my people to come get the vehicle? She said, yeah. Well, she testified that she testified that she got information from basically her precinct or her superior that no, we're coming to get the vehicle. So his argument was there was really no specific justification for the vehicle to be impounded. And the judge pretty much agreed with that. There was no information that was provided as to why you would impound the vehicle. And then we know there was like a dog sniffing search and all of that. And I don't think that brought anything like a drug. There was no reason really to get a dog to sniff for drugs. Like, they were just doing stuff. And then, like, when you looked at the videos of Detective Field, she was patrol officer at that time. She was looking at stuff in the vehicle and you saw it on the body cam where she pretty much was saying things like, oh yeah, we got to get search warrants for this and this and that. But we're back at the original premise of why did you impound this vehicle in the first place? So that's what his attorney artfully argued. So they're saying if the vehicle is legally parked and poses no threat or danger, which she testified that it was parked in a parking lot, it was a private property. It wasn't like anyone was saying move the vehicle. They weren't saying you're obstructing our business. There was no danger. It wasn't like impeding traffic. And they established that in the hearing, that it was no reason to basically impound the car. He should have been able to call someone. They said impoundment violates the Fourth Amendment protections against unreasonable seizures. Because the impoundment of the white Ford F-350 was illegal, all subsequent actions taken by law enforcement officers the following day were also unlawful. The Fourth Amendment guarantees the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The ultimate test for the validity of the police's conduct is whether, under the circumstances then confronting the police, their conduct was reasonable within the meanings of the Fourth Amendment, and that's in Wren v. U.S. Furthermore, the state bears the burden of showing that each individual act constituting a search and seizure under the Fourth Amendment was reasonable. So, as they are applying the law to the facts, and they said, as stated above, Mr. Williams was arrested on the warrant out of Roswell for theft by deception on July 7, 2022, while driving his wife's white Ford F-350. Afterwards, officers illegally impounded the white Ford F-350 and had the vehicle towed to the Roswell Police Department lot. At no time did any officer memorialize or articulate that they had probable cause to impound or subsequently search the Ford F-350. Even with the complete lack of reasonable suspicion or probable cause, officers still searched the vehicle in violation of Mr. Williams' Fourth Amendment constitutional rights. Based solely on evidence found because of the illegal search, officers then secure warrants for multiple properties. So that answers your question. Like, no, based on the search, as I explained before, they were able to secure warrants to search his properties. And that's when they found a lot of this stuff that's in the list. And they're saying all of this stuff is fruit of the poisonous tree. And so therefore it should be excluded. When no search warrants were executed, officers secured subsequent warrants for items and vehicles discovered. The state never demonstrated officers had enough probable cause to secure search warrants for the above listed residences and locations before they arrested Mr. Williams and searched his vehicle. Furthermore, the state also never presented any evidence that the inevitable discovery doctrine exception or the independent source doctrine exception applies here. Well, that's pretty much what the state is going to argue, as we'll see in a minute, on this new filing from today. The state's own police report shows officers started reaching out to alleged victims and swearing out other warrants only after the arrest and multiple searches took place. So they're saying, they're arguing that they didn't reach out to any of these victims or anybody or anything related to these people until after he was already arrested and they searched his vehicle, which makes all of this stuff fruit of the poisonous tree, and it should be excluded. For the inevitable discovery exception to apply, there must be reasonable probability that the evidence in question would have been discovered by lawful means, and the prosecution must demonstrate that the lawful means which made discovery inevitable were possessed by the police and were being actively pursued prior to the occurrence of the legal conduct. The mere fact that the investigator obtained a warrant on the following day is not enough to bring the case within inevitable discovery. Now, what I will say is that the officer did say that they started investigating Mr. Williams a month before. That's how they knew who he was when she happened to pass him. So there was an issue, if you guys have been following this case, and we have several videos on it, of which the landlord to that place on Pine Grove basically said there's some suspicious activity going on with the person in his house of which he was renting. So then that's when they ran plays. That's when they found the names of all these different individuals. So I didn't necessarily agree that all of this stuff came from, they knew who Ernest Williams was because they had been watching him for like 30 days based on a person, a landlord that came in and said, I done got some bounce checks. I think it's some shady stuff going on in his house. I don't know what's going on. So okay. The exception involves no speculative elements, but focuses on demonstrated historical facts capable of ready verification or impeachment. The rule regarding the independent source doctrine exception is clear. If the second lawful search was not prompted by the prior unlawful search, then the independent source doctrine applies, and the state is in the same position it would have been in if the lawful conduct had not occurred. But if the second search was prompted by the original unlawful search, then the evidence must be excluded so that the state does not benefit from the unlawful conduct. Under such circumstances, the independent source. So they're saying the independent source doctrine and inevitable discovery, which we'll go over in the state's response, does not apply. So this is the document that was kept from the public, basically, until, and I don't know why. Like there was no, we were always able to get all the documents. This is the judge knows this is a media case because I put in Rule 22s and other people have. So why it was not all of a sudden it was under seal or something was like, what? But basically the state said in their motion to dismiss that there was no orders of that. And so that's why they attached it to their motion. So anyway, let's go on. So on today, there was something else that was filed. Let me see. Which is the state's response to this supplemental brief to suppress. Again, this is the response to this one, which is what the judge asked and requested at the last hearing. Separate and apart, there is the motion to dismiss based on other reasonings, standing, which we'll get into when we get into that conversation. But right now we're just talking about the responses for the court's request that there be supplemental briefs be submitted. So let's go. So this is the state's response that was filed on today at 12:05 a.m. on February 4th of 2025. And it basically says, comes now the state of Georgia by and through the undersigned counsel in response to the defendant's supplemental brief. Y'all see it say 277 pages. Y'all see that up there at the top? 277 pages. Make sure y'all, it's over 1,000 of you guys in here. Make sure you hit the like button, please. Subscribe to the channel if you have not done so already. So the state goes on to say the defendant filed his motion to suppress on September 30th of 2024, and the state filed a response on October 25th of 2024. A partial hearing was held on December 18th of 2024, and the court heard testimony and argument related to whether the seizure of a Ford F-350 vehicle was lawful under the Fourth Amendment. At the conclusion of testimony and argument, the court directed the parties to file supplemental briefs related to what, if any, of the state's evidence would constitute fruit of the poisonous tree if the court ultimately ruled that the seizure of the Ford F-350 was unlawful. The defendant filed a supplemental brief on January 6, 2025, of which I just went over, challenging a large volume of the state's evidence, and the state now responds in opposition. As set forth below, only a handful of items found in the Ford F-350 listed in Section 8 below would be subject to suppression if the court were to conclude that the Ford F-350 was unlawfully seized. So they're saying it's only a handful of items. So then they go on to what we were just discussing about inevitable discovery, independent source, and attenuation doctrine. Okay, so the exclusionary rule is a judicially created remedy designed to deter police misconduct by suppressing the use of evidence obtained in violation of the defendant's constitutional rights. The rule prohibits use of evidence seized during an unlawful search, testimony concerning information acquired during the unlawful search, and evidence and testimony, quote, that is the product of the primary evidence or that is otherwise acquired as an indirect result of the unlawful search up to the point where the taint is dissipated, I can't even talk, dissipated by its attenuated connection with the unlawful search. So they're basically going over what the exclusionary rule is, which I done said about 10 times since we've been on here, so I'm just going to move on. So let's talk about their definition of inevitable discovery doctrine. The Supreme Court of the United States has held that unlawfully obtained evidence remains admissible if the prosecution can establish by a preponderance of the evidence that the information ultimately or inevitably would have been discovered by lawful means. So if they can prove that regardless to whether this search was legal or not, we would have found this anyway, then that's the inevitable discovery doctrine. We would have got it regardless. So they have to prove that they would have got it regardless to whether this search happened or not. Under the exception for inevitable discovery, the government may introduce evidence that was obtained by an illegal search if the government can establish a reasonable probability that the evidence in question would have been discovered by lawful means. The government must also establish that the lawful means which made discovery inevitable were being actively pursued prior to the occurrence of the illegal conduct. The exception exists because exclusion of physical evidence that would inevitably have been discovered adds nothing to either the integrity or fairness of a criminal trial. And then we go to the independent source doctrine. Applies to evidence initially discovered during or as a consequence of an unlawful search, but later obtained independently from activities untainted by the initial illegality. So the independent source would be like, okay, maybe you got Scretchen's number, but we were able to look up Scretchen online and seeing that she filed a police report against you anyway. Like there's an independent source as the separate and apart from the information that was found in the truck. Like the inevitable discovery doctrine, the purpose of the independent source doctrine is to put the police in the same, not worse position than they would have been in if no police error or misconduct had occurred. Intertwined with both the inevitable discovery and independent source doctrine in Brown v. Illinois, the Supreme Court of the United States explained that fruit of the poisonous tree need not be suppressed if the taint of an unlawful search seizure is attenuated by intervening circumstances. Attenuation is determined by three factors: the temporary proximity of the illegal conduct and independent discovery of evidence, the presence of intervening circumstances, and particularly the purpose and flagrancy of the official misconduct. Moreover, the Supreme Court has explained that courts should apply the exclusionary rule far more skeptically to live witness testimony than they might to innate tangible evidence. So, inanimate tangible evidence. So we know that there are live testimony here. I'm trying to see what I could skip. That's why I'm looking, because this is long. Okay, so let's go to the relevant facts and arguments. Okay. Let me check. Y'all all right? Y'all all right over here? It's 1,200 of you guys. Make sure you hit that like button. Thank you so much. Bonnie said if it's found that the truck was illegally searched and not admissible, that's the child P and SA information. However, he has multiple other charges that will keep him. That's what I always said, that it seems like the laptop would not have been found but for that search. However, Wooten is actually arguing in a motion to dismiss that the search is not unlawful, that whole vehicle suppression should be dismissed, essentially because that wasn't your truck. And you got it fraudulently when you married Shirley Strawberry. And I think Shirley didn't give him permission or something. They put a lot of stuff in that dismissal, where it sounds like they have obviously talked to Shirley Strawberry and she's very cooperative in this matter. Okay. So, yeah. Thank you, DMV, for the super sticker. I appreciate that. So, thank you. So, yeah, let's go on, man. Let's go on, because there's a lot going on here. It's a lot of exhibits. So, pre-trial, they said the relevant facts and as a general consideration, it should be noted that the defendant himself has previously acknowledged, quote, the inordinate amount of publicity that has been given and will be given to this case leading up to and during trial. And then they're quoting from the defendant's motion for a gag order. Remember, they was trying to get a gag order and they didn't want me up in there recording and stuff. They didn't want us up in. They were like objecting to my Rule 22s and stuff like that. So they're quoting them that this has been an inordinate amount of publicity. As examples, the defendant arrest and the Roswell Police Department's ongoing investigation were reported by multiple media outlets, including in online articles and television broadcasts beginning in early of October 2022. So they have Exhibit A, which is a bunch of articles. So we'll go through those when we get to the exhibits. Each of these articles encouraged potential victims to contact the Roswell Police Department, and multiple victims, in fact, came forward. So basically, the clarion call for anybody that were alleged victims of Mr. Williams, they're saying multiple people came forward and said, me too, me too, me too. In addition, when the defendant was indicted by the Fulton County Grand Jury, several media outlets published articles and broadcast television stories encouraging potential victims to contact the state, and multiple victims, in fact, came forward. Finally, as the court is aware, various YouTube content creators, thank you so much for the shout out, regularly report on this case, further expanding public awareness and encouraging victims to come forward. This pre-trial publicity and media exposure is relevant in the context of the inevitable discovery and attenuation doctrines, to the extent that the defendant generally challenges evidence related to victims Gretchen, Bickham, Washington, and Delaney. Because of this extensive coverage across multiple platforms, these victims would have had multiple opportunities to discover the investigation of this case and come forward, as many others have, independent of any evidence found as a result of. They saying because we talking about them so much, they were going to come forward anyway. They're like, have you seen these YouTubers lately? Have you seen these news these broadcasts and all of these news channels reporting on this. If we had, I mean, they were gonna come forward anyway. And that is truth to that, because I've had people that have emailed me alleging things. I just, again, I'm a document type of a person, and I followed the case, and I try to be very as strict as possible to that being what we talk about over here. And there are other channels that expand and they give more opinionated and they do interviews. That's what they do. But I've had some people that allege to be close to Mr. Williams that have reached out to me and tried to tell me some things too. So that is true. And a lot of that is based on, I'm saying that is true as far as people that will reach out to you when you're doing this type of media work. So that is what the state is arguing on the inevitable discovery. Let's go on. I know you lying. I know it's not one no, it's 1.2 in here and it's 662 likes. Okay, I'm gonna need y'all to get these likes up. Thank you so much. I appreciate the support. Right, we made ink. That's what we say when we make like the paper and stuff. The YouTubers that made ink. Okay, let's go on. Victim scratching. So they're giving us information about what they have against the alleged victims. The defendant appears to assert that certain evidence and testimony related to victim Melody Scratching should be suppressed if the court determines that the Ford F-350 was unlawfully seized. The defendant does not identify what specific evidence or testimony should be suppressed, but instead merely points out that a piece of paper with Melody Scratching's credit card number was located inside the Ford F-350 and briefly summarizes a telephone interview with Ms. Scratching conducted by police on August 15, 2022, more than a month after the search of the F-350. It is unclear to the state whether the defendant's position is that only the piece of paper should be suppressed, all evidence and testimony related to Ms. Scratching should be suppressed, or something in between. Out of an abundance of caution and to provide relevant factual background to the court, the state will assume that the defendant challenges all evidence and testimony related to Ms. Scratching. But for the reasons set forth below, the state submits that only the single piece of paper is subject to suppression if the court determines that the F-350 was illegally seized. So they're saying that little piece of paper with her credit card, y'all can have that. We don't even need that. And this is the reason why. Ms. Scratching purchased a 2018 Nissan Altima on December 5th of 2018. They have Exhibit B of that Nissan Altima purchase. Let me go down here. What page is this? Let me go down to Exhibit B. See how long this is? Told you we're going to be here for a minute. So these are the articles they mentioned. There go our girl Erica. There go Ernest. So they got the Atlanta News First article. That's the one we all saw at first. WSB TV Atlanta 2. Couple charged with fraud. That's why they got the whole that's in the phone conversations where they were trying to say Erica and Ernest was messing with each other, but she has denied that, as you guys seen when I talked to her. She denied it. This is Exhibit B. So this is the vehicle tags that they're talking about right now. Okay. So let's go back. Vehicle title. Ms. Scratching purchased a 2018 Nissan Altima on December 5th of 2018, and it has the title and tag information as Exhibit B. As the defendant acknowledged, Ms. Scratching, quote, reported her car stolen by the defendant on June 4, 2022. So that was a month before, with the South Fulton Police Department, well in advance of the seizure. So then they have the Exhibit C, which has the police report. Ms. Scratching told police that she was looking to sell her 2018 Nissan Altima and that defendant offered to sell it for her because he, quote, knew someone that would buy her vehicle for more than what the dealership was offering her. And so they have that report at page 3. In January 2022, Ms. Gretchen permitted the defendant to take her vehicle to be sold. Several months passed, during which time Ms. Gretchen repeatedly asked the defendant for her vehicle back or the money he sold it for. The defendant gave Ms. Gretchen the runaround before she finally realized he was not going to return the vehicle, prompting her to file a police report. As a result of that report, an arrest warrant was issued for the defendant on June 5th of 2022. That's Exhibit D. The defendant was arrested on that warrant by Detective Natalie Fields. So this is the arrest warrant that Natalie Fields was arresting him on, was about Miss Gretchen, the day that she pulled him over. And that's Exhibit D. The defendant was arrested on that warrant by Miss Fields on July 7th, the same day the Ford F-350 was seized. Fulton County Jail booking report, it is also unquestionable that an investigation into the crimes committed against Miss Gretchen by the defendant was being actively pursued prior to the seizure of the Ford F-350. So remember, as we read, apparently Miss Gretchen, they accused her of filing a false police report. I believe it was her, but it was some investigation that was going on. No, that wasn't Gretchen. I think that was somebody else. Let me take that back. They're basically saying there was an investigation into Gretchen's allegations against Mr. Williams, obviously, if there was a warrant for his arrest. So it was already an active investigation. So anything with Miss Gretchen, like it's an independent source, you know. Subsequent events and investigation revealed that the defendant had given the 2018 Nissan Altima he stole from Miss Gretchen to another of his victims, who was unaware that the vehicle was stolen. We went over all of that in the incident reports early on. We first started talking about this a couple years ago. Just 2 days after Miss Gretchen reported her vehicle stolen to the South Fulton Police Department, her grandmother, Tracy Simmons, who was also unaware that the vehicle was stolen, was arrested for driving a stolen vehicle in Conyers, Georgia. Miss Simmons was removed from the vehicle at gunpoint and was made to lie face down on the ground during her arrest. Ms. Simmons stated to police that she first saw her granddaughter with the vehicle on January 2022, consistent with statements made by Ms. Gretchen to South Fulton Police Department. Conyers Police Department officers immediately contacted Ms. Gretchen to notify her that her vehicle was stolen by the defendant had been located. All of this occurred well before the seizure of the Ford F-350. This is what I told y'all. I was like, I seen the incident reports and people were filing stuff before he was even arrested or the seizure happened. The defendant also acknowledges that Ms. Gretchen filed a report regarding the use of her credit card for items not authorized with the South Fulton Police Department. So basically they have Exhibit G. There was a police report, and that report was made on August 13, 2022. Ms. Gretchen stated that she had previously reported that the defendant stole her 2018 Nissan Altima and that she needed to follow up to report that he had also used her credit card without authorization. The defendant told Ms. Gretchen that, quote, he had a hookup at BrandsMart USA to help her buy items for her home. So she provided her credit card information to him. Instead of using Ms. Gretchen's credit card information to purchase items for her at BrandsMart USA, the defendant used Ms. Gretchen's Family First Credit Union card, SunTrust card, and Carnival World MasterCard to purchase items for himself without Ms. Gretchen's authorization. In October 2023, once the defendant cases had been received by the Fulton County DA's office, Ms. Gretchen provided a written statement to the state confirming all of the above details and provided copies of credit card statements documenting the unauthorized transaction. That's Exhibit H. Gretchen's statement of financial documents. So let's go down here to some of these exhibits, man. We can't get too far. Let's see, before we get to the next alleged victim. So we went over the articles. So Exhibit B is the title. Exhibit C is the incident report, which we went over. That was the theft by deception with Gretchen. Went over that in the previous video. Incident report related to, okay, the vehicle list. Exhibit D is, no, notice that. Oh, this is the warrant. Okay. What Oh, this got the Los Angeles stuff on there. So at the time she filed it, they said Mr. Williams has multiple active warrants in reference to theft. The warrants are as follows. There was fraud in Los Angeles, larceny out of Henry County, fraud out of Orange County, California, and theft by deception out of Roswell. So even by the time Miss Gretchen, submitted her allegations to the police, there were already active warrants when they looked them up. Exhibit E is the booking report. We went over that too, I think. Then they have the case report, Conyers Police Department. On Monday, June 6, 2022, at approximately 8:57 hours, I responded to the area of Navy Federal to assist in locating a stolen vehicle that hit on a local tag reader. Conyers Communications advised they located the vehicle, a 2018 Nissan Altima bearing Georgia tag, on camera in the Navy Federal parking lot and observed a female in the vehicle. Sergeant Cook and I approached the vehicle and made contact with the female in the driver's seat. The female, later identified as Tracy Simmons, exited the vehicle and was detained in handcuffs with her hands to the rear of her person. Conyers Communications confirmed the vehicle was stolen out of Fulton County, and Sergeant Cook began searching the vehicle as I questioned Simmons. I first read Simmons her Miranda rights, and she understood and agreed to speak with us. So this is the whole when she says it was her granddaughter's car. So they have attached receipts, what the internet calls receipts, and we call evidence. Okay. That's what the state is attaching here to show they had independent information outside of what was in that vehicle. So let's see. So that was scratching. So now we're on Gail Bickham. Okay. To prevent dry mouth while reading the Thank you so much for the super chat. Right. Where is my apple juice? I thought I brought something down here. Oh, I do. Got my little juice box. There's a lot going on in here. I told you guys we was going to be here for almost an hour, and I ain't even halfway through the second document. Let's get into Gail Bickham. The defendant appears to assert that certain evidence and testimony related to victim Gail Bickham should be suppressed if the court determines that the Ford F-350 was unlawfully seized. The defendant again does not identify what specific evidence or testimony should be suppressed, but instead merely points out that a check from Wade Ford for $2,852 and invoices from the sale of the 2012 Mercedes-Benz G-Wagon were located inside the Ford F-350, and briefly summarized an interview with Ms. Bickham conducted by police on October 13, 2022, more than 3 months after the search of the Ford F-350. It is unclear to the state whether the defendant's position is that only the check and invoices should be suppressed, all evidence and testimony related to Ms. Bickham should be suppressed, or something in between. Out of an abundance of caution, again, and to provide relevant factual background to the court, the state will assume that the defendant challenges all evidence and testimony related to Ms. Bickham, but for the reasons set forth below, the state submits that none of these items are subject to suppression, even if the court determines that the F-350 was illegally seized. Okay. Police conducted a lengthy interview with Ms. Bickham on October 13th of 2022, during which she explained how she met the defendant in 2009 or 2010, and how he had attempted to entice her to enter into several business deals with him over the years. In June 2021, the defendant contacted Ms. Bickham and offered to help her develop her real estate business. Ms. Bickham believed that the defendant's offer was legitimate because he appeared to be connected to wealthy investors through the marriage to Shirley Strawberry. Ms. Bickham had recently purchased a 2021 Mercedes-Benz GLE class vehicle that was fully paid off. The defendant coerced Ms. Bickham into signing the title of the vehicle over to him so that he could sell or trade it in for another vehicle that he claimed would help improve her image. On June 29th, we read this incident report too. On June 29, 2021, the defendant purchased a 1998 Prevost Royale vehicle using Ms. Bickham's funds after the defendant led her to believe the vehicle was being purchased for her business. Instead, the defendant registered the vehicle in his own business's name. So they're alleging that I guess she was supposed to upgrade. He was supposed to help her upgrade her vehicle, which I don't see what was wrong with her vehicle. 2021 Benz back then, I mean, it was a newer vehicle. And what he did was he traded it in, got a 98 Prevost Royale vehicle with her funds, allegedly, and basically registered to himself. 2 months later, on August 21st, 2021, the defendant traded in Ms. Bickham's GLE class vehicle and the 98 Prevost Royale vehicle purchased using Ms. Bickham's funds for a 2002 Prevost Liberty vehicle without Ms. Bickham's knowledge or consent. The 2002 Prevost Liberty vehicle was also registered in the defendant's business name. Approximately 1 year later, on June 30th, 2022, the defendant traded in the 2002 Prevost Liberty vehicle and another vehicle for a 21 Mercedes-Benz G-Class vehicle or G-Wagon at Wade Ford, again without Ms. Bickham's knowledge or consent. Ms. Bickham provided a large number of documents to police and to the state, including documentation of the various vehicles purchases and documentation of her communication with the defendant. Some of those communications demonstrate that Ms. Bickham made multiple demands to have her property returned throughout 21 and 22, and she indicated multiple times to the defendant that she would involve third parties if necessary. On October 13th of 21, Ms. Bickham stated to the defendant, "Will you be providing me with the car this evening? I cannot take this as a total loss and do nothing. You can either give me the title to that coach, give me money, or I will contact all parties who have received money and an asset from me to get all paperwork." And that's Exhibit I. Text messages. On October 27, 2021, Ms. Bickham stated to the defendant, "Since you choose not to perform, return calls, or provide the check, I need an exact date on when you will either return my money or provide me with the title to that coach you purchased in Arizona and requested receipts. I will not go out empty-handed or carry the horrible feeling of robbed at trust and mouth point." Wow. She said she was robbed at trust and mouth point. Didn't he say he got a mouthpiece? "I will not go out empty-handed or carry the horrible feeling of robbed at trust and mouthpiece." So those are exhibits we'll go over in a second. Those are text messages on October 28th of 2021. Ms. Bickham stated to the defendant, "Since you refuse to talk to me about you have, perhaps it's best you talk to someone you will listen to." On December 28th, Ms. Bickham stated to the defendant, "I want my money back. If you do not wish to handle this with me, then perhaps you will be willing to address it with someone else on my behalf." That's Exhibit K. Text messages. On January 4th, Ms. Bickham stated to the defendant, "Your profile is that of a scammer you stole money and property from. It's called theft by taking. It's a form of fraud as you establish oral agreements and refuse to perform. You believe you will get away with stealing from me and possibly a multitude of others. You won't." Based on Ms. Bickham's voluntary interviews with police and the state, the large number of documents she provided to police and to the state, and many text messages sent by her to the defendant indicating that she will pursue legal remedies, Ms. Bickham's cooperation with the prosecution is clearly voluntary, and there is no direct causal connection between any illegal police conduct and Ms. Bickham's willingness to participate in the prosecution and testify. Moreover, the defendant's accomplice and co-defendant, Erica King, I told y'all she been singing like a bird since this all started. She been singing. Listen, Erica said that she was not going to go out like this, okay? So now we hear what Erica has, some of the stuff that Erica alleges when she was talking, because she was talking from the beginning. That's why she got out so fast. So it says, as part of that, it says, Moreover, the defendant's accomplice and co-defendant Erica King agreed to cooperate with the state in exchange for leniency in sentencing. As part of that cooperation, Ms. King was required to proffer information to Roswell Police Department as part of its ongoing investigation. Of relevance to Ms. Bickham, Ms. King was interviewed several times, and stated that the defendant had taken money from Ms. Bickham for the purchase of a G-Wagon during an interview on April 11th of 2023. That's just last year, Mr. Williams. The following exchange took place. This is Detective Field. Why so many buses? What women have you met along the way? Ms. King said, the bus, that particular bus, that was an older bus. And I knew that someone wanted to buy the bus and the defendant wanted $15,000. When he came back from California, he got a new bus. He told me that he had a woman who bought the bus for cash, Gail Bickham, $250,000. She gave him and he bought the bus with the money. She apologized for not believing in him, but they had something going on. So Ms. King said it was something going on. So then later in that same interview, the following exchange took place. Detective Field said, how do you think he got the G-Wagon for Shirley for her birthday? Y'all remember the G-Wagon that got taken over there at the hair salon? Erica said, I think he took money from Gail. He just told me he had gotten the money from her, but I don't know what form the money was in. In a subsequent interview on April 20th, 2023, the following exchange took place. Detective Field says, what happened to Gail's Mercedes? Ms. King said, I don't know. He said Gail had a G-Wagon. To my knowledge, she was working with him. He drove most places in the bus. So on the trip to Arizona, it was my understanding that they were all traveling on the bus, they being all the girls. I never met Gail. Everything I know about Gail is from Nesto. She was giving him money because she felt bad about not believing in him before. Though police were aware of Ms. Bickham prior to Ms. King's interview, had they not been aware of her, they would have learned about Ms. Bickham through Ms. King's cooperation. Ms. King specifically stated multiple times that Ms. Bickham had given the defendant large sums of money and indicated that the defendant had purchased a G-Wagon using money, quote, taken from Ms. Bickham. Based on those statements alone, police inevitably would have contacted Ms. Bickham and discovered her status as a victim. As set forth above, nothing related to Ms. Bickham is subject to suppression. All evidence related to Ms. Bickham either was known or reported prior to the seizure of the Ford F-350, would have inevitably been discovered, was discovered from a source independent of the Ford F-350, or sufficiently attenuated such that the taint is cured. Erica is spilling all, yes, Lou to Delu. All the tea. She is telling everything. Let's go peruse down here to these text messages. Let's see what's in this exhibit. Let's go see. So we went through. Let's see. I told you the state attached. They had authority for everything they talking about. Okay. So let's get to some text messages here. So this is the incident report from Scratching. Okay. Let's see. This was Scratching. She did a letter about all of the credit cards too. Lord have mercy. Exhibit I. These are the text messages. Oh shit. I should have turned these around, huh? Let me see. Can I turn this around? Okay. I've waited all day. Will you be providing me with the car this evening? I've been very patient. I've made it clear what I am facing. You have gone dark 30. I cannot take this as a total loss and do nothing. You can either give me the title to that coach, give me money, or I will contact all parties who have received money and an asset for me to get all paperwork. I do not fear you. In the same way my problems are not of concern to you, no one else's problems are of concern to me. If you or whoever you know hunt me down to bring some form of harm to me, then so be it. Oh my goodness. But I will not accept you taking all that you have and not honoring your word or returning what you and your syndicates have taken. By the way, I do not believe you are out of town. This is not what good people who mean well do to good people who mean well. I have been financially harmed by you, and it has taken a horrible toll on me physically. I am being as rational and forthcoming as humanly possible in hopes that you will understand that business relations of any sort between you and I is not and will never be possible because you don't honor your word and follow through with your commitments made to Gail Bickham. Why is she talking in third person? If you do not have the money because you don't have that amount of money, tell me, and that will be that for now. But if you have my money and you are just refusing to return it after consistently demonstrating your inability to perform for whatever reason, this is not good, brother. This is not good. What if someone did this to your daughter? How would you feel? Oh my. Here's another one. They got Ernesto Buckhead Scammer. Where did that come? Oh, that's what she got him in her phone, is Ernesto Buckhead Scammer. So then it has these. It shows the BMW colors I selected. Good morning. What is your schedule today? Greetings. I am open. Okay. Do you know if you're getting your car today? If so, let me know. I need for you to drop the car off at Butler Tire in Buckhead, and I will pick you up. That's if you're getting your car today. The car has not yet arrived. We'll need a car if you would like this one dropped off. It's okay. I'll make apartment to be done later today or tomorrow for the nail and the tire, I guess, appointment. Greetings. A good Friday to you. This was October 22nd of 21. Have an amazingly productive and fruitful day. Greetings and good Saturday. Following up on a meeting for the check. October 23rd. Cutting out early, touching base with you. October 23rd. Are you able to meet up with me tomorrow around 7:30 or 8? Please call Gail. Thank you. I will need the check tomorrow. Would be nice to see you today. Checking on a time to meet today. She got him as Ernesto. Happy Wednesday. Today is a magnificent day, and all that is good is ours to be had. Please let me know when you will be available. Thanks. If I don't hear from you today, I will choose to believe all of your actions over your words. Have a great day. Respectfully speaking, it's after 5 p.m. You indicated you would call back. You indicated you would have a check for me days, weeks, months ago, and I still have nothing in return from you. Since you choose not to perform, return calls, or provide a check, I need an exact date on when you will either return my money or provide me with the title to the coach you purchased in Arizona and request the receipts. This is all you, not me. I will not go out empty-handed or carry the horrible feeling of robbed at trust and mouse point. There is no robbery in fair exchange. We have no fair exchange of anything. Only you can resolve this matter. Best we handle it all between the two of us. On standby. And she got a little emoji of the sun. She's so delightful. The problem is not going to magically disappear. This October 28th of 2021. Since you refuse to talk to me about perhaps it's best you talk to someone you will listen to. This is all you, not me. I will not go out empty-handed or carry the horrible feeling of robbed at trust and mouth. There's no rob. Okay, that's the same thing. Then she got, you don't have to know today's scripture. The Lord will work out his plans for my life, for your faithful love, O Lord, endures forever. Not quoting Psalms 138, the 8th, the one, chapter 138, verse 8. When Moses led the 2 million Israelites out of slavery into the desert and towards the promised land, I can imagine them asking him, what route are we going to take? Where are we going to get food and water? How will we protect ourselves? Moses answered, I don't know. Just because you don't know how something is going to work out doesn't mean God doesn't have a plan. Moses had such a trust in God that he was comfortable not knowing. He took it one step of faith at a time. When we're trying to figure everything out and manipulate a solution, we're being God. It's very freeing when you learn this principle that it's okay to say, as Moses did, I don't know how it's going to work, but I'm at peace. You're taking yourself off the throne and putting God on the throne. Take the pressure off. You don't have to know. God knows. He will work out his plan and get you to where you're supposed to be. A prayer for today. Father, thank you that what lies ahead and is unknown to me, well known to you. I choose to rely on your strength and your word to guide me step by step. I trust that you will go before me with your plan and get me to where I'm supposed to be. In Jesus' name, amen. That is what he sent her. Wait a minute. Then on October 28th, she says, just seeing this, prayer is always good. However, I don't recall Moses breaking commitments. Okay. Oh gosh, I'm sorry, y'all. I didn't read any of this. Oh my goodness. High Vibe said, I'm dead. This trial is going to be lit. Okay, if this goes to trial, this trial is going to be lit with some of these women. Oh my gosh. Okay, is that it? No. The gravity of your own golden rule, and I am certain you are not prepared. You can call or not call. You can make it right or not make it right. No matter what, when the year ends, the tipping point begins. You can trust yourself and keep doing what you are doing, or trust God and do what you know you should do. In this situation, the two are not the same. Okay. December 25th. So this was on Christmas. Good morning and Merry Christmas. Tell someone I really truly have faith in one day you will understand the position and power you have. Only God can show you the path of your greatness. No man or woman can do that for you. So I speak only positive for the people I care about, and I care about you. Thank you for being in my life. This is not real. This is not real. She responds. She responded on the 27th, title, paperwork or nothing. Which is it? She said, keep your bull. I am clear on whose I am and the power vested in me. But all of that does not mean walk away from $250,000 in cash and assets. May God bless us both with every desire of goodness in our mind and hearts. This is my prayer for protection. I want my money back, December 28th. If you do not wish to handle this with me, then perhaps you will be willing to address it with someone else on my behalf. For a contract, including an oral contract, to be valid, it must have the 3 essential elements. She done pulled up the law, okay? It must have 3 essential elements of an enforceable agreement: offer, acceptance, and consideration. That is true. You learn that in contracts. When it comes to everything you did not do, all of the above has been established, or it's theft by taking. You choose. My goodness. Okay. What does it matter? This is Atlanta, and this is what scammers do. Your profile is that of a scammer. You stole money and property from. It's called theft by taking. It's a form of fraud as you establish oral agreement and refuse to perform. You believe you will get away with stealing from me and possibly a multitude of others. You won't. Here he go on January 5th. Is that 5th? Yeah, January 5th. Good afternoon. I'm just getting back. Happy New Year. Like nothing happened. Good afternoon. I'm just getting back. Happy New Year to you. I see all the texts you sent me. Wow, I never knew you felt that way. It's okay. I forgive you. God has a plan for everybody in the world. Make sure you stop looking at so much TV. That is a negative energy. Have a great day. I won't be texting you anymore. You can call me with your positive energy. I'm not taking any more negativity in my life. Believe it. What? What is you saying about me? Whew. Okay. It's 1,400 of you guys in here. Please hit the like button and subscribe to the channel. We get into the nitty gritty of some of this information that the state has against Ernest Williams. And then she responded, "You won't." So then here's another text from Thursday, January 6th. Oh, no, that's the same one. Said, "Thanks. Only the truth sets us free. Facts and numbers did not lie. Negative 250,000 for me, plus 250,000 for you with absolutely no results." A businessman makes things right. A business scam does not. You created the reality, not me. Happy New Year, and may the truth set you free. So then he goes on to say, "Good afternoon. I tried to call you several times, but I think you're going effing crazy. So don't effing text me anymore. If you got something to say to me, call me. Don't threaten me or assume anything anymore, because I know the effing truth. And if you want to play the games, come on with it. I'm ready for real. I don't run for anyone, and I don't do anything to anybody. So stop with the BS." Except he say the word, the bullshit. "Like I said, if you ready to play the game, let's go. I promise you I'm ready." Whoa. He went from "Jesus is the light, light of the world," to "I'm ready for it. Bring it." Like, oh my goodness. It's the gangster. All right. So those were the text messages from our girl Bickham. Okay, let's go back up here. Whoa, were those some reads right there? Told you guys these doggone exhibits can be a whole separate situation here. Okay, I gotta turn all these back around now. Hold on. Okay, all right. So now we're going to Miss Washington. The defendant appears to assert that certain evidence and testimony related to victim Washington should be suppressed if the court determines that the F-350 was unlawfully seized. The defendant does not identify what evidence or testimony should be suppressed, but instead merely states that Ms. Washington was interviewed by Roswell Police Department on August 27th of 2022, nearly 2 months after the search of the F-350 regarding a 2021 Harley Davidson the defendant stole from her. The defendant's motion fails to articulate in writing specific facts connecting the interview of Ms. Washington to the search of the Ford F-350 as required by statute. To the extent the defendant may argue that evidence and testimony related to Ms. Washington was derived from the search warrant executed at 980 Pine Grove Road, and that said search warrant relied on evidence obtained from the Ford F-350, this argument fails both legally and factually. Legally, for the reasons set forth more fully in Section 7 below, the defendant lacks standing to challenge the 980 Pine Grove Road search because that residence was procured by fraud. And in any case, the search warrant for 980 Pine Grove did not rely on any evidence located in the Ford F-350. Factually, Ms. Washington was not interviewed because of any evidence located in the Ford F-350, but instead because she independently reported her motorcycle stolen to the Forsyth County Sheriff's Office. We went over that case too, which prompted Roswell Police Department officers to contact her. As such, nothing related to Ms. Washington is subject to suppression. So let's get into the Miss Washington facts. Miss Washington purchased a 2021 Harley Davidson motorcycle on May 6, 2021, and that's an Exhibit L where they have the title and the tag info and the bill of sale. On August 26, 2022, Ms. Washington called upon the police to report that the defendant had stolen her motorcycle, and that's an Exhibit M where we'll see the police report. She stated that on May 4, 2022, she agreed to let the defendant use her motorcycle while she borrowed an ambulance. Y'all remember the ambulance? That was in his possession. Ms. Washington then attempted to get her motorcycle back from the defendant because the ambulance had an expired tag and no insurance and was therefore undrivable, but she was unable to contact or locate the defendant. As disclosed in body-worn camera footage provided to the defendant in discovery, Detective Fields called Ms. Washington on August 27, 2022, the day after Ms. Washington made the report to Forsyth County. In that footage, Detective Field explained she was contacting Ms. Washington because Harley Davidson had contacted her after the motorcycle was reported stolen. Ms. Washington stated she had also sent a demand letter to the defendant's last known address. Roswell PD report excerpt. As set forth above, nothing related to Ms. Washington is subject to suppression. All evidence related to Ms. Washington either was known or reported prior to the seizure of the Ford F-350 would have inevitably been discovered, was discovered from a source independent of the Ford F-350, or sufficiently attenuated such that any taint is cured. Now we get to Regina Delaney. We went over her stuff. Now, she was the one that reported it, and it's the Zoom hearings and all of that, okay? So let's get into hers, then we'll go and we'll connect those exhibits, okay, from Washington and Delaney, because I don't feel like scrolling and flipping it around right now. The defendant appears to assert that certain evidence and testimony related to victim Regina Delaney should be suppressed if the court determines that the Ford F-350 was unlawfully seized. The defendant does not identify what evidence or testimony should be suppressed, but instead merely states that Ms. Delaney was interviewed twice by Roswell Police Department regarding a 2020 Harley Davidson motorcycle the defendant stole from her. The interviews occurred on September 15, 2022 and September 16, 2022, more than 2 months after the search of the Ford F-350. The defendant also omits pertinent facts in an attempt to discredit Ms. Delaney. The defendant fails to articulate any facts connecting the interviews of Ms. Delaney to the seizure of the Ford F-350. To the extent the defendant may argue that evidence and testimony related to Ms. Delaney was derived from the search warrant executed at 980 Pine Grove Road, and that said search warrant relied on evidence obtained from the Ford F-350, this argument fails as a matter of law. First, for the reasons set forth more fully in Section 7 below, the defendant lacks standing to challenge the 980 Pine Grove Road search because, you guessed it, that residence was procured by fraud, and in any case, the search warrant for 980 Pine Grove did not rely on any evidence located in the Ford F-350. Secondly, investigations into the crimes committed against Ms. Washington by the defendant had been actively pursued prior to the seizure of the Ford F-350, and the evidence obtained by Roswell Police Department either already had been obtained by other law enforcement would have been inevitably discovered as a result of this investigation. As such, nothing related to Ms. Delaney is subject to suppression. So let's get into the facts of Ms. Delaney. Ms. Delaney purchased a 2021 Big Tex TL trailer on August 4th of 2020. That's Exhibit O. And it has the title, tag information, and the bill of sale. She purchased a 2020 Harley Davidson motorcycle on September 5th of 2020. That's an Exhibit P. The vehicle, title, and tag information, bill of sale on March 15th, more than a year before the seizure of the Ford F-350, Ms. Delaney reported to the Sandy Springs Police Department that the defendant had stolen her motorcycle and trailer. Ms. Delaney told police that the defendant called her on November 7th of 2020 while she was in the hospital after a car accident and falsely stated that her apartment leasing office contacted him and told him to remove the motorcycle and trailer from the parking lot. She permitted him to do so. So basically, she's saying she was in the hospital. She get a call from him that's like, oh, the apartment complex, they contacted me and said you can't leave this trailer and stuff in your parking lot. So she was like, okay, we'll go ahead and pick it up. Ms. Delaney made multiple attempts to get her motorcycle and trailer back from the defendant, but he stated that he would not give them back to her unless she paid him $20,000. After Miss Delaney's initial police report was filed, SSPD Detective Isaiah Tomlin was assigned to investigate the case. During the course of the investigation, Detective Tomlin advised that Miss Delaney would need to send a demand letter to the defendant instructing him to return her motorcycle and trailer in order to designate them as stolen, which she did on March 19th. That's Exhibit R. Okay. Let's get to some of these exhibits. Oh, they're going to get into Erica King representing them. Hold on. Let's get to these exhibits. Okay. Exhibits. Let's see. I know y'all sick of me scrolling like this, but you know. I don't know what page it's on. Okay. So we got to L, I think. Got all the text messages. Okay. L. Okay. So that's the title for Washington's information. Okay, Exhibit M was the incident report for Miss Washington that we just discussed. So I spoke with Olivia Washington. She stated on May 4, 2022, she was moving out of her house at the above address. A friend of hers, Ernest Williams, was helping her out. He allowed her to use an ambulance of his with tag number for an undetermined length of time. In exchange, Olivia let Ernesto use her Harley Davidson motorcycle with the tag number for an undetermined amount of time. Since then, Olivia stated communication stopped with Nesto. She tried calling him, and the number she had for him was disconnected. She does not know where he lives or works. Olivia stated that he left her with the ambulance with expired tags and no insurance, and she wants her motorcycle back. I requested that Olivia send me an email statement and a photo of the motorcycle. I will add it to the report attachment folder when I receive it. Olivia said that she knew Ernesto sometime drove a Ford truck with a tag number. I attempted to contact the registered owner of that vehicle, Shirley Strawberry, but there was no answer. Olivia stated that Shirley was Ernesto's wife. So Shirley, you got this call. What is this? August 26th of 2022. So this was what, a month after his arrest. So they was trying to contact you to get information too. And I'm sure the people left a message. They probably said, hello, my name is Detective so-and-so. Okay, Shirley, I'm not going to get on you right now. So this is another incident report. Let's go to Exhibit N. So this is her phone interview. So they got the transcript. I asked Washington how she met Williams, and she stated that she met him at a Starbucks on October 2022. She was working at Uber Eats, and he opened the door for her. Williams started having a conversation with her, and they exchanged phone numbers, just friends, no relationship. Washington was in a living situation, and Williams let her live in one of his ambulances. Live? Washington was trying to get in touch with him as the tag was expired. I asked Washington what Williams wanted to speak with her about, and she stated that he wanted to understand what she did as he could make her more money. Williams offered Washington to work for him at his security company, but Washington said no. Washington said she was working in security for other people as well as driving school buses. I asked Washington how she was paying for the bike, and she stated that she was paying the monthly payments as well as the insurance. Washington stated he did help her with the $4,500 down payment, but she was paying him back. I asked Washington if she knew of Regina Delaney, and she stated that Williams told her she was incarcerated and had kids. Washington asked if Delaney's bike was black, and I said yes. She stated that she had seen the bike on his truck. Washington also told me that Delaney had a Can-Am that she had crashed. Washington stated that Williams had Washington drive the F-350 with the black bike over to Williams' home. Washington stated Williams had multiple vehicles, according to Washington, a lot of police-type cars. Washington said Williams asked Washington for her social security number and driver's license number on May 6, 2022, because he was going to get her a trailer for her bike. Washington also stated that Williams would ask her to Zelle money to the girls and was never reimbursed. Washington was helping Williams with moving cars and met the girls, but she believed Williams was just her friend. Washington did file a police report with Chambly at first, but then later went to Forsyth and filed a report. What is happening? What is happening right now? Okay, you guys hit that like button. Okay, we've been reading for a minute. We've been on for an hour and a half. Okay, it's a lot of information we're trying to get through here. Glad that you came, honey. You're gonna have to hit that rewind because there's been a lot going on in this here live right here. I came back with fireworks. All right. Jana said this is wild. Yes, this is definitely wild. This is all alleged. CCB said, who are the girls? That is a good question. Why y'all keep asking about Joey? What did Joey say? Diddy's baby oil. What did Joey say? Okay, let's go on because, honey, we're going to be here all night. So Exhibit O is the vehicle tags and all of that, I think, for Delaney, because that's who we're on, Regina Delaney. Then it got the big text invoice. Then there's a vehicle title again for this another vehicle. Yes, another vehicle. Then we got the Harley Davidson. This is the receipt for the Harley Davidson. Exhibit Q is the incident report from Sandy Springs Police Department. This is from Delaney. We went over that before in another video. This was on March 15, 2021. I was dispatched to a motor vehicle theft call. Upon arrival, I met with Regina Delaney. Regina advised that her Harley Davidson motorcycle was taken on November 7th of 2020 while she was in the hospital. She then advised that the motorcycle was on a trailer with the lock on that hitch of the trailer. Regina then advised that it was taken by a salon business partner and friend by the name of Ernesto Williams, who was 5'2" black male that lived on blank. Regina advised that Ernesto called her on November 7th while she was in the hospital, claiming her leasing office called him to remove the trailer with the motorcycle in it because it was taking up too much space. She was not able to give the exact hour it occurred. Regina advised that she tried to get the motorcycle and trailer back from him in February 25th, 2021, but he refused. Regina then advised that on March 12th, he showed up to her apartment with the motorcycle and trailer, which was the last time she physically saw her belongings, and told her that she could only have the motorcycle and trailer if she paid him $20K. Regina advised that she refused, and he drove off with the trailer and motorcycle. I was not able to identify Ernesto Williams through GCIC. I also tried to contact the number provided for Ernesto and was unable to, probably because they was looking up Ernesto instead of Ernest. Regina was given a case number and victim's right card. Due to not being able to confirm or receive a statement from the suspect, no warrant was issued. Ernesto Williams, not on file. The motorcycle and trailer was not placed on GCIC because his date of birth was in question. Unable to locate a match. And so this is cleared by arrest. Cleared by, okay, what is this? On March 16, 21, I contacted a manager at the Arabelle Parameter apartment, which is located blank. The manager advised the complex had only ever had one vehicle towed from the location and that they typically never make those types of calls. When they do, they use the company A Tow, which is the same company used by the police department. The manager knew who Delaney was and added that she had presented false information on her rental paperwork and that she had been renting the apartment under the name of Crystal Flowers. From the conversation, I understood that the property had Delaney evicted for using a fraudulent name. I reviewed the body cam footage of Officer Laura from when he met with Delaney to make the initial report. In the video, Delaney claimed the suspect brought the motorcycle back to her on the trailer and that he wanted $20K before he would give it back. Delaney claimed that he then drove away from the area. I attempted to make contact with Delaney, but she did not answer. I left a voice message requesting a call back. I requested assistance with reviewing traffic cameras in the area of Peachtree and Dunwoody Road and Hammond Drive Sandy Springs Police Department GIS analyst Brian stated that she viewed the cameras at the nearby intersection and never saw a truck with a motorcycle on a trailer come through the area between 1900 and 2000 hours. I later made a copy of the footage from these cameras. So this must be when they're saying she filed a false police report. I later made a copy of the footage from these cameras for similar time period, added them to my case file. On March 18, 21, I made contact with Delaney. Delaney began by explaining that she had originally purchased a Can-Am Ryker and the Harley Davidson at the same time on August 2nd, 2020. Delaney stated that she had a bad accident on the Ryker and caused her to be hospitalized. I saw a report of this using a law enforcement database, and I saw that the reported accident was made on August 9th, 2020. Delaney stated that this occurred on August 8th. After the wreck, Delaney said that she was in a wheelchair and was not completely mobile for some time. In November of 2020, she had been contacted by her leasing office and was informed they needed her to move her trailer and motorcycle to a different part of the parking deck due to it being in the way of other traffic inside the parking deck. Delaney stated that she texted Williams on November 7th of 2020 and mentioned to him that she would like him to move the trailer for her, but he was not able to do it on that day that she requested. So this is kind of contradictory because at first she said she was in the hospital and the apartment building, I guess, called him, and said it needed to be moved. So she said, okay. But now it sounds like she's saying that she called him. So anyway, Williams contacted her later on in the week while she was at Grady Hospital and said that a member of the maintenance crew at the apartment complex had asked him to come and remove the trailer. Williams informed Delaney that he had transported the trailer to his own home. Delaney then asked Williams to bring the trailer back to her residence, but he did not, and an argument ensued. Delaney continued to contact William about the motorcycle and trailer, and around the end of November, he told her that she could come pick up the motorcycle and trailer from him at his home. Delaney arranged for a tow truck to go to the location to pick up the items, but they were not there, and she confronted Williams about the issue yet again. Delaney continued to contact Williams throughout December, and she reported that he told her that he wanted to keep the motorcycle for a while because he made a down payment along with her when it was originally purchased, and that he wanted to keep it until he had his money's worth from it. Delaney continued to contact Williams throughout January, but he stopped replying to her during that period. So it looks like she cleared by arrest, false representation to police, cleared by arrest. Okay. In February 2021, this is long. Good gosh. Wait a minute. All right, we're going to have to go through that separately because this is a lot. Oh my gosh. Okay. So this was the demand letter that I guess the police told her to write Williams on March 19th of 2021. Attention, Ernesto Williams. This letter is an attempt to collect property that has been wrongly misplaced. The return of a 2020 Harley Davidson, they got the VIN numbers and the trailer and the VIN number, should be returned within 5 days from the receipt date of this letter. If items are not returned within 5 business days, there will be a $100 convenience fee per item every day until items are returned to the owner's possession. All court and attorney fees will be included if further action is required. So that's the demand letter that the police told her that she needed to send Nesto. So this was the response, okay? This is from Goldberg Sutton LLP. So this is one of March 25th of 2021. Dear Detective Tomlin, I am writing you on behalf of Mr. Ernest Williams regarding the dispute between Mr. Williams and Regina Delaney. We are appreciative of your persistence to contact Mr. Williams and make him aware of the accusations made against him by Regina Delaney. Per our conversation on yesterday, my office is sending over information detailing Mr. Williams' 2020 affair, Regina Delaney. That is some terrible grammar. I am sending over this information confidentially regarding the 2020 Harley Davidson. According to Mr. Williams, he and Miss Delaney had a personal relationship with business intertwined, which was short lived, leading to their now civil dispute regarding the property. So this sounds like Sonia's argument. They was in a relationship and then it went south, and now she's claiming that he stole from her. On several occasions, Mr. Williams physically returned a motorcycle and trailer to Miss Delaney. He states that Miss Delaney begged him to accept the bike back and urged him not to leave it at her place of residence. Since that time, Mr. Williams has had the motorcycle and the trailer in his possession at all his expense. Mr. Williams is wanting the money that he has paid to cover the Harley's monthly payments, expenses, insurance, as well as upgrades that he has installed on the motorcycle. Once Mr. Williams gave Miss Delaney a demand to return his money, she has sought out Sandy Springs police to intervene. Is this dispute between the two parties? On several recent occasions, Miss Delaney has shown up to Mr. Williams' place of business in the Buckhead community dressed in all black, acting irrational. The criminal record of Miss Regina Delaney has also been brought to Mr. Williams' attention. No, he didn't. No, they didn't. No, they aren't talking about criminal records. Mr. Williams is a community businessman and would rather not be friends with someone who has recent history of criminal activity. Okay, I gotta walk away from this one. What? What? He said, Mr. Williams is a community businessman and would rather not be friends with someone who has recent history of criminal activity. This correspondence also includes video and photo evidence of Mr. Williams' account of the matter. If you have any further questions or are in need of any further information, please feel free to contact my office via telephone or email. And this is from, y'all know, April Holloway, aka Erica King. And there's the incident report, Delaney v. Williams. Please advise our office if you need anything further as to what the next course of action would be, if any. Oh, we had good afternoon, Detective Tomlin. Per your request, I have attached a letter of response written on behalf of Mr. Ernest Williams. The links below also contain the video and photo evidence of Mr. Williams' claims. This is a communication from a debt collector. What? Why is this? Why? April Holloway, Esquire, case manager. So apparently there's links or something, yeah. Oh gosh, I'm not doing this. So she a debt collector too? She was acting like she was trying to get the debt from him or something? Please excuse any typos in my last message. I apologize. I am rushing out of my office. Have a great evening. Hello, Tomlin. Please see attached. Mr. Laney is posting messages via Instagram directed at Mr. Williams and his spouse, making inflamed accusations. In these messages, she is also tagging major blogs and media. So on April 9th of 2021, so she's trying to contact to get help from the detective, saying that Delaney is actually. So on Instagram, people were up under Shirley Strawberry, or this lady was under Shirley Strawberry's post, letting her know what was up. And so Erica, or April Holloway, is trying to use this stuff against Delaney, saying that this stuff is not accurate, and she's basically going on the internet lying on him. She got the drop box with timestamps. I wonder if I could click it. I'm gonna go do that right now. I'm scared to click the link. Shoot, it might put a virus on my computer or something. This was the magistrate. Okay. Remember the notice of appearance? This is when she came in as April Holloway, substitution of counsel. There go your girl. Look how different she looks, y'all. This is her on the Zoom. On the Delaney hearing. Shorty the just hit me up in the email, okay? I heard you were married to her, Shorty the comedian. I asked her about you. She said it was all lies. I actually have a recording. If you want to come on and debunk anything, I'll make an exception for you on the interviews. Yeah, that's Nesto next to her. Yes. You said I thought that was Tiffany Superman. Nope, that's Erica. Y'all know I got all those recordings. I asked her a lot of stuff. But Kelly said, please do an interview. Just let me know whenever you're ready. When you're ready to tell your story, just let me know. I got you. Yeah, that's Ernest in the back. Thank you, VA Bunny, for becoming a member. I appreciate that. It does look like her, but no, I told you. That's why they said she was a chameleon. She's changed. Well, she's sick now. She has some health challenges, and so she's blown up because she's on steroids. So she doesn't even look like the same person anymore. Sunflower the Babe said she really is a woman of many faces, because who the F is that? That's the queen of the South. What are you talking about? You said, we'll see. I got a lot to say. It was a lot done. Erica's very dangerous. Do not underestimate her. I'm going to tell it. All right. Well, you just let me know. I can tell by how she was talking to me. Trust me. When I talked to her, I picked up on some things. That girl said, I bet you she's slim right now. All right, y'all. We've been on forever, and we still have not gotten through this document. Let's see what's after this before we go. Okay, remember I told you it got denied? I was like, she actually won that hearing. So we went over this in another video with Regina Delaney. She was trying to get him arrested. She was trying to get a warrant. They appeared on this Zoom. That's what this was. She said she was Erica Hollowell. And that's Nesto sitting right there, the one that didn't even know she was doing anything. Didn't know she really wasn't no lawyer. And she wanted for him. Like the court denied her getting a warrant to get her property back. Mm-hmm. Grandma Sally said, Pam, I have been bored with Nasty Nesto for a bit. Thanks for bringing some new interesting information. Listen. All right, y'all. Let's see. I'm scared to know what's next. Exhibit Z. We on Exhibit Z. What is this? Oh, some of the cases. All right, let's go back up here to read the rest of some of this stuff. And I told y'all in the title, I was like, he has attached a whole lot of stuff too. Oh, it's some more stuff with Erica King. So we about to get some more into Erica. All right. I should have put that thumbnail up there, her. Okay, so on March 24th, Detective Tomlin received a phone call from the defendant and an individual purporting to be attorney April Holloway. We know that was Erica. Unknown to Detective Tomlin, the individual purporting to be attorney Holloway was actually Erica King, the defendant's accomplice in several related crimes. Ms. King has since pleaded guilty to conspiracy to commit unauthorized practice of law, filing false documents, identity fraud, and making false statements for conspiring with the defendant to assume the identities of attorney Holloway and several other attorneys. Remember, the judge, when I was there for Erica's plea, the judge did not accept the sentencing, because the way the sentencing was going to be, what their agreement was with the state was that she would not have to be on probation. She wouldn't be, it was like deferred. Like, okay, you going about your life, and if you don't get in trouble, you'll be fine. You didn't have to report. You didn't have any type of restitution. It was just going about your life and don't get in trouble anymore, pretty much. Even though she was, it was deferred. She was on paper, so she wasn't going to have to do any time in jail. And the judge was livid, like, absolutely not. This lady done pled to 50,000 counts, and you think she's not even going to be on paper? She still got a sweet deal, but it wasn't as sweet as what the origination was. So I figured she must have gave a whole lot of information, whether it be true or not, because the state is going to have to deal with her past and her credibility too if she gets on the stand. But I mean, it's competing against Ernest Williams' credibility in his past. So anyways, Erica King, they attached the final disposition as Exhibit S. We just went past that. Detective Tomlin believed Ms. King's lies and instructed her to provide evidence. So Detective Tomlin believed Erica that the defendant did not actually steal the motorcycle or trailer. On March 25th, 2021, Ms. King sent a letter to Detective Tomlin, that's what we just read, on behalf of the defendant using a fraudulent law firm letterhead in the name of Goldberg Sutton LLP and using attorney Holloway's identity that included patently false and defamatory statements about Ms. Delaney. Remember, we have the videos and the hearings of the real April Holloway and how she said this affected her life. She had to go before the bar and basically defend her license and everything, that make sure that it didn't affect her trust accounts where you keep your client's money. She was going through, I believe, some sicknesses and deaths in her family at the time. And she was talking about how she didn't care what the sentence was. She said, don't ever do anything like this again. She was there to do an impact statement at the time of the sentencing of Erica King. Between April 5th, 2021 and April 9th, 2021, Ms. King sent multiple emails to Detective Tomlin on behalf of the defendant using attorney Holloway's identity that included multiple false statements. That's an Exhibit U that we just went over. Emails to Detective Tomlin. As a result of the defendant and Ms. King's conspiracy to lie to and deceive Detective Tomlin, Miss Delaney, a victim of the defendant's crimes, was wrongly charged with making false statements to police and was wrongly arrested on April 21st, 2021. So basically, Erica was so believable that the detective was like, oh, okay, so this lady here, Miss Delaney, she's lying. And so Miss Delaney was actually charged and arrested for filing a false police report based on Erica King's work as a fake attorney. That's crazy. Erica gonna get on the stand to convince the judge and juror with those changing personalities. I didn't know that, y'all. I did not know that Miss Delaney had actually been arrested, charged and arrested because they didn't believe her. I knew she lost the case with Erica King representing him related to trying to get a warrant, but I did not know that she actually was charged with filing a false police report. So I said that's why Nesto Carter, Queen of the South. Oh my goodness. But the conspiracy against Miss Delaney didn't stop there. On July 11, 2021, prior to making a report to the Sandy Springs Police Department, Miss Delaney filed a warrant application, that's what we just went over, against the defendant in Fulton County Magistrate Court for stealing her motorcycle and trailer. So then there's the application, Exhibit V, the warrant application affidavit. Miss King, once again, falsely using the identity of Attorney Holloway, filed a notice of appearance in the case on February 7th, 2022, claiming to be, quote, counsel for defendant Ernesto Williams. So then they got the notice of appearance attached. On the same day, a video recorded Zoom hearing, which has been provided to the defendant in discovery, was held before the Fulton County Magistrate Court Judge Ashley Drake. I was trying to get that video, and they were like, they changed their policy or something where now you had to be a part of the case or something in order to get it. Because I sure was trying to see, like, can I get that video? Is that okay to get? But anyways, Miss King using Attorney Holloway's identity, and the defendant appeared on video sitting next to each other. Miss King designated her name on the Zoom application as Attorney April Holloway, but at some point during the hearing, her name on the Zoom application apparently inadvertently reverted to Erica King. Judge Drake noticed the name change and the following exchange occurred. Okay, now we got the exchange on what happened when the Zoom name changed to Erica King while she was on there. We heard about that. Now we got the transcript. So this is what happened. The Judge Drake said, is your name April Holloway? Why does it say Erica King? Miss King said, Judge, that is my paralegal's name. I can go in and rename it. So it's when I'm coming back on, I renamed it. So I jumped right into the hearing. I didn't have time to change my name. She had a quick response. The judge said, okay, well, this is a recorded hearing. So at some point, please rename yourself your name. So then several minutes later, presumably because Judge Drake had become suspicious of Miss King, a further exchange occurred. Judge Drake said, Miss Holloway, can you just confirm your bar number? Miss King said, yes, my bar number. Can I send that in the chat, please? Judge Drake said, your bar number is secret? Like, man, we always have to announce our bar number every time we get on anything. It's on every pleading. It's on the bottom of your signature line. Like, is that a secret? So then Miss King said, I said, can I send that in the chat, please? Because with Miss Delaney, we've had a lot of issues with her. The judge said, okay, but I mean, my understanding it's a matter of, Miss King said, I've dealt with a lot of harassment. The judge said, you can put your bar number in the chat, but I mean, your bar number is on your entry of appearance, which is filed into the case. A bar number is not a secret. It's a matter of public record, and ultimately, I'm not entirely sure why it's such a secret. I mean, my bar number is 476-555. I hear you, Judge. Me, P75243. I understand. I hear you, Judge. That's how I am with my bar number too, Judge. Miss King said, so I will send it over to you. Let me explain to you that my firm is a family law firm. We represent high-profile individuals. Mr. Ernesto is married to a high-profile celebrity, and we've had tons of issue with Miss Delaney in reference to this case. Her comebacks are like there, okay? Okay. Miss King said, it's my right to protect my. No, Judge Drake said, I understand, but that. And so I told you that you can send your bar number through the chat if that's absolutely necessary, but it's not like it's a secret. The bar number that you are sending, Miss King said, it is my right to protect myself because, again, this woman has a lengthy. The judge said, Miss Holloway, send your bar number through the chat. So Miss King says she has a lengthy criminal history. So then the judge said, send your bar number through the chat. Miss King said, yes, ma'am, I'll do so right away, Your Honor. Judge Drake said, Miss Holloway, I haven't received a chat yet. Miss King said, yes, I'm sending it. My client was talking to me at the same time, so I have a fiduciary responsibility to my client as well as to the courts, Your Honor. Give me one moment, please. Y'all, I cannot with this. Kiki in DC said, yeah, Sonya would never been the next Erica. She ain't quick. Erica is on her toes, okay? You see how it just, like, that could not have been anything. That could not have been anything that she even perceived could happen. That you get on there, you put April Holloway, and then somehow you jump off, and then when you come back in, it goes to your default, which was Erica King every time you got on Zoom, and you were able to say, this lady got a criminal record, she's harassing me. No, she started out and said this Erica King was her paralegal. That just came to her like that. It was no gap in the conversation. None of that. She was just like, oh, Erica King, that's my paralegal. I jumped onto her video. She would. Work in Progress says she would have been great if she really did try to practice law. I think she said she does have a couple degrees. Then she's like, but literally, see, the thing is what the judge is getting at. Your bar number is like your social security number. You know it like by heart. You say it so much. I think I knew my bar number the first week I got it because you say it so much. So you know your bar number off the top of your head. And I think that's really what, for her to be like, well, I'll just put it in the chat. Then you got to prolong and linger because now she probably got to find the lady's bar number because the judge probably looked it up to see if April Holloway existed. So now she got to go try to find where she put the bar number at and then try to type it. But ultimately, you should know it by heart because you use it so much. Some courts make you introduce yourself with your bar number. It's definitely on every document that you have. Like every time you file a pleading, it's like on your caption. So, yeah. Wasn't Erica an activist? I was surprised when I heard she was caught up with Nesta on his criminal activity. I ain't never heard of Erica being no activist. Y'all heard that before? I've never heard that. Well, her ex-husband said that she's no activist. He's going to tell his story. So we'll see. She said, because remember, I think Tasha K mentioned, because it was something with Charleston White and it was a lot of stuff that Tasha K brought up, and she was acting. When I asked her those questions, she didn't know what I was talking about. She was like, who is Charleston White, huh? That's those Bond said, is activist another term for liar? Okay, I mean, hey, she may have been. TD will say yes, if Erica used her knowledge for good, she would have been unstoppable. For sure. For sure. I always say when it comes to like people that work at Chrysler or something, it may take them 3 years to come up with a security system, and it'll take a criminal 5 minutes to learn how to undo it and drive away with your car. So she gets active. All right, let's go on, y'all. So now we have, moreover, the state employ every possible resource to locate potential victims of the defendant during the district attorney's office pre-indictment investigation of this case. In addition to the general publicity and public calls for victims to come forward, both by the Roswell Police Department and the DA's office, the state utilized public court records, including Fulton County's Odyssey system, to locate other criminal and civil cases brought against the defendant. Multiple victims were located in this matter, including Drusilla Scott, which is in count 1, Jasmine Collins, Mario Alvarado, Crystal Waters, Melvin Stokes, Juan Smith. These were all that were cases filed in Odyssey. Then they got all the complaints. They don't went to Z. They got exhibit AA, exhibit BB, CC, DD, and EE. Okay. Juan Smith and warrant application. In addition to these, Ms. Delaney's case against the defendant appears when searching for the defendant's name or his aliases in the Odyssey system, and Mr. Delaney would have inevitably been discovered as a victim in this manner. See exhibit FF. As set forth above, nothing related to Ms. Delaney is subject to suppression. All evidence related to Ms. Delaney either was known or reported prior to the seizure of the Ford F-350 would have inevitably been discovered from a source independent of the Ford F-350 or is sufficiently attenuated such that any taint is cured. So that is Miss Delaney. And they also mentioned some Odyssey searches, because if you do put his name in, a bunch of stuff pops up about different cases, both criminal and civil. So now we got the 990 Pine Grove Road search warrant. The defendant appears to assert that all evidence found during the lawful search of the 990 Pine Grove Road residence should be suppressed if the court determines that the Ford F-350 was unlawfully seized. The defendant's motion fails to articulate in writing specific facts connected to the 990 Pine Grove Road search to the search of the Ford F-350 as required by statute. Instead, he merely lists the items seized during that search. In any case, the defendant's challenge to the 990 Pine Grove Road search fails for two reasons. First, the defendant lacks standing to challenge the Pine Grove Road because, it was procured by fraud. Second, even if he did have standing, the issuance of the 990 Pine Grove Road warrant did not depend on any evidence found in the Ford F-350. Okay, so basically the claim protection guaranteed by the Fourth Amendment, the defendant must demonstrate first that he exhibited an actual expectation of privacy in the thing or place searched, and second, that the expectation is one that society is prepared to recognize as reasonable. Where a defendant cannot establish both a subjective expectation of privacy, basically he shouldn't have an expectation of privacy in a place he wasn't supposed to have, okay? Let's move on. Georgia courts have rejected the proposition that society is prepared to recognize any legitimate expectation of privacy in property that is stolen or procured by fraud. That's what I was just saying, but there's your authority right there. I knew that's what they were getting at with all this case law, and I'm trying to, move faster. And then they got numerous federal cases are on record about the expectation of privacy. You don't have one if you got it by fraud. Here, the defendant lacks standing in twofold. And that's the same argument that they are saying about the F-350, because the marriage of Shirley Strawberry was allegedly procured by fraud because he obviously was married to someone else when he married her. And Shirley Strawberry, they said, would be expected to testify that had she known he was married, obviously she wouldn't have married him. And then also it sounds like he may have gotten that truck in her name without her knowing. So yeah, there were little things here and there that were happening that it sounds like Shirley just was like, shoot, he driving me around, he got nice cars, he's buying me new rings and trucks, and he put on a good persona for the public. Okay, so they're saying he lacks standing. First, the 990 Pine Grove Road was never leased to the defendant, and he never established even a subjective expectation of privacy in that residence. The only tenants listed in the 990 Pine Grove Road lease was James Relaford and Candy Relaford, which is aka Erica and her husband. 990 Pine Grove Road lease. The lease expressly prohibited subletting. The lease did not include the defendant. So this is the house next door that they're talking about they search. And then they talk about different things in the lease, and you can't sublet it, so you're not a part of this lease. Second, even if the defendant had a subjective expectation of privacy in 990 Pine Grove Road, That expectation was objectively unreasonable because the residence was procured by fraud. On January 13th, 990 Pine Grove Road was purportedly leased to James and Candy Relaford, but Candy Relaford was a fraudulent identity assumed by the defendant's accomplice, Erica King. The 990 Pine Grove Road lease was purportedly brokered by real estate agent Tammy Strong, but Tammy Strong was also a fraudulent identity assumed by Miss King for the purpose of receiving $1,000 commission on the deal, which she in fact received. Okay, so what they are saying is that Erica King acted like she was an agent so that she could receive an $1,000 leasing fee for a referral fee, but she was referring the property to herself, who was Candy Relaford. So Erica King was an agent who got a referral fee for leasing the property out to herself under a different name. Erica. Bambi said, girl, what? You cannot make this stuff up. You cannot. I didn't see all of this coming. I didn't. You know, we see a lot of this because I did read the incident report, so we scratched the surface here. But we didn't know all of this. We had no clue. Call me darling, said my poor brain would be fried trying to hustle all these things and keep them in order and keep them straight. All right, let's go on. Let me see. Wait a minute. No, that was case law that you're talking about. Okay. That commission just kind of threw me off. Receiving $1,000 commission on the deal, which she in fact received. All right. It has the signature of Candy Relaford and Tammy Strong on the lease were forgeries made by Miss King, 990 Pine Grove Road, lease at 12. While Miss King paid the first 2 months rent at 990 Pine Grove, rent had not been paid in several months and was at least $13,500 in arrears at the time of the search. On April 6, 2022, Ms. King provided a check in the amount of $4,450 to the 990 Pine Grove Road landlord. The check was returned for insufficient. The account holder on the check was listed as Candy Relaford. The bank name was listed as Urban Trust Bank, and the account number was listed notably as discussed in Section 7 below. On the same day, on April 6, 2022, another check was sent to Seasons Comforts Heating and Air for work done at 980 Pine Grove Road, rented by the defendant, using the bank name Urban Trust Bank and the same account number. That check was also returned for insufficient funds, had the account holder listed as Black Heritage Radio Trust Association and was signed by the defendant. On June 3rd, 2022, more than a month before the 990 Pine Grove Road search, a dispossessory affidavit was filed in 990 Pine Grove Road to initiate eviction proceedings. We went over that too. Dispossessory affidavit. The affidavit and summons were served on Ms. King under Candy Relaford alias on July 8th of 2022. No, we went over the other Pine Grove. We didn't go over hers. The same day, the 990 Pine Grove Road search warrant was executed. Marshall's entry of service based on the above, the defendant had no reasonable expectation of privacy. Basically, you had no expectation of privacy because all this stuff was fraudulent. Even assuming for the sake of argument that the defendant has standing to challenge the 990 Grove Road search and that information in the search warrant affidavit had been obtained unlawfully, the search was lawful. When determining the validity of a search warrant issued pursuant to an affidavit that contains both lawfully and unlawfully obtained evidence, a trial court must first determine whether, after exercising information regarding unlawfully obtained evidence from the warrant affidavit, the remaining evidence is sufficient to support finding a probable cause. Second, the trial court must determine whether the officer's decision to obtain a search warrant was prompted by what he observed illegally. On its face, the affidavit supporting the 990 Pine Grove Road search warrant survives this test. Okay. I guess I'll read the rest of it. The affidavit contains 22 numbered paragraphs. You can see the search warrant. Of those, only half of paragraph 18 and the whole paragraph 19, 20, and 21 contain information related to the seizure and search of the Ford F-350. The only fact contained in any of those paragraphs arguably related to 990 Pine Grove Road is that police located paperwork related to a 2014 Bentley that had been seen parked at the neighboring residence of 980 Pine Grove. That's the one we went over. Based on the affidavit alone, it is clear, even after excising half of paragraph 18 and the whole of paragraph 19 and 21, the 990 Pine Grove Road search warrant remains supported by PC, probable cause. Okay, now we get to the 980 Pine Grove search warrant. The defendant appears to assert that all evidence found during the lawful search of the 980 Pine Grove Road residence should be suppressed if the court determines that the F-350 was unlawfully seized. The defendant's motion fails to articulate in writing specific facts connecting the 980 Pine Grove Road search to the search of the Ford F-350 as required by statute. Instead, he merely lists the items seized during that search. In any case, just like his challenge to the 990 Pine Grove Road search, the defendant's challenge to the 980 Pine Grove Road search fails for two reasons. First, the defendant lacks standing to challenge the 990 Pine Grove search because the residence was procured by what? Fraud. Second, even if he did have standing, the issuance of the 980 Pine Grove Road search warrant did not depend on any evidence found in the F-350. Okay, so then they go back over the subjective expectations and all of that. Let me skip down to the facts. As such, even if the defendant had a subjective expectation of privacy in the 980 Pine Grove Road, that expectation was objectively unreasonable because the residence was procured by fraud. As a starting point, the lease itself was fraudulent. First, the lease came about when the defendant's accomplice, Erica King, contacted landlord Mark Crow using the fraudulent identity of Candy Relaford. Now we're getting into the house next door from Erica King, of which, even if you do Google searches from back then, you know how they have pictures where you can go historically. You see like Nesto security, like I seen a car in the driveway. If you go like to the old Google searches. So this is the house next door. And so we're going to get into information about that. Of course, we talked about that in earlier videos when we first started discussing this case. The lease itself purported to have been an agreement between Mr. Crow and an entity called Black Heritage Radio Trust. 980 Pine Grove Road lease. Subsequent investigation revealed that Black Heritage Radio Trust, Inc. was a fraudulent business entity created for the purpose of fraudulently renting 980 Pine Grove Road. So this Black Heritage Radio Trust don't even exist. Documents reviewed by police show that the defendant and Ms. King provided false documents to Mr. Crow to procure the lease, including tax documents with a different business entity name, Black Heritage Broadcast Radio Trust, Inc. Not they submitted tax documents. Other false documents provided to Mr. Crow included one indicating Black Heritage Radio Trust, Inc. was associated with an address in Wellington, Florida, but open source records revealed no legitimate connection to that address. Another document listed an employer ID number purportedly associated with Black Heritage Radio Trust, but police investigation revealed the EIN provided was false. Moreover, several of the trust formation documents provided to Mr. Crow purported to have been prepared by Goldberg Sutton, the same law firm name fraudulently used by defendant and Ms. King described in section 5 above. Finally, the lease itself was notarized using a stolen identity and forged notary stamp. What? The lease purports to have been notarized by Amanda Johnson, who received her notary commission in Cherokee County, Georgia. Only one notary named Amanda Johnson was commissioned in Cherokee County at the time of the lease was signed. Police contacted Ms. Johnson, who confirmed that she did not notarize the 980 Pine Grove lease and that the notary stamp on the lease did not match her actual notary stamp. Amanda Johnson, oh my gosh, and we got this is unbelievable. Moreover, rent had not been paid in several months and was thousands of dollars in arrears at the time of the search, and the defendant and Ms. King had provided multiple checks to the landlord and have been returned for insufficient funds, including the deposit check written at the time the lease was signed. Check number 0099 returned for non-sufficient funds. Notably, as discussed in section 6 above, one of the return checks sent to Seasons Comfort Heating and Air for work done at 980 Pine Grove used the bank account name Urban Trust Bank and the same account number as another return check delivered by Ms. King to the 990 Pine Grove Road landlord. Mr. Crow provided an invoice to the defendant for a total of $32,980 in unpaid rent and fees for the period from March 15, 2022 through June 15, 2022. 980 Pine Grove invoice is attached as Exhibit PP. On June 8, 2022, a month before the 980 Pine Grove Road search warrant was executed, Mr. Crow filed a dispossessory affidavit on 980 Pine Grove Road to initiate eviction proceedings. See Exhibit QQ. We went over that. A certificate of service on the defendant was filed the same day. Finally, 2 days later, the defendant and Ms. King delivered a fraudulent cease and desist letter to Mr. and Mrs. Crow on Goldberg Sutton LLP letterhead using the stolen identity of Eileen Nicole Mormon, an Atlanta criminal defense attorney. Oh my God. The letter falsely stated that Miss Mormon represented Black Heritage Radio Association Trust and accused Mr. and Mrs. Crow of criminal trespass and illegal surveillance. The letter threatened litigation and confirmed that the defendant had received notice of the eviction proceeding initiated against him. And it had on there, lastly, please provide our office with a copy of your eviction complaint and or mail to our office or send via sheriff entry of service. Based on the above, the defendant had no reasonable expectation of privacy in the 980 Pine Grove Road residence because the residence was procured entirely by fraud. As such, the defendant has no standing to challenge the search of 980 Grove Road. Oh my God. Jeez, oh Pete. Even assuming for the sake of argument that the defendant has standing to challenge the Grove Road search and some information in the search warrant had been obtained unlawfully, the search was lawful. Okay. Let's go down here to some more exhibits. We're almost at the bottom of the document. So we left off at Exhibit Z. So we're in the double letters now. Y'all hanging in there. I know. I told you guys we're going to be here for a while. Thank you all for your patience. I'm trying to get through this here document. Make sure you hit that like button because your girl had to put in some work. There go our girl Erica again. There she go. Okay, so this was the cases. So basically, Exhibit Z was all of the cases they were able to look up on Odyssey. This is a case where Drusilla filed against Nesto. Here's BB is another case where Jasmine filed against Nesto. This is an indictment. It's another indictment. So these are all before his arrest. So this indictment is June 19th, 2015. So they're adding all of these different people they were able to find by just doing a search online is what. So this is the residential property with James Relaford and Candy Relaford, that they were saying all of this stuff is fraudulente. So that's the lease. And then you have a search warrant. Okay. Exhibit II is the dispossessory affidavit that they filed against Erica King, aka Candy Relaford. So those are all of the eviction paperwork. Then here's the lease. This, I guess this was Nesto's. This is Exhibit LL. The Georgia Standard Residential Lease Agreement. They got Mark Crow. Then the tenant is Black Heritage Radio. So this is supposed to be the lease. Let's see what's at the bottom here. Mark Kroll is on here. That got Sheridan Strawberry. Remember her name was coming up. Tenant signature Ernest Williams. Print name Ernest Williams. And this is the fake notary stamp that they were talking about. And this is from Amanda Johnson, who said, "This is not my work. This notary is fraudulent. Attaches a copy of my actual seal." So she sent this to Natalie Fields to let her know that was not her. So this is her actual seal, which is different than, like, where did they find this stuff from? January of 2025. No, hers is January 13th of 2025. So it even got the wrong date on there. And then here's the checks, the fraudulent checks. And then he has how much is owed on here. This is from the 980 Pine Grove for Black Heritage Radio. Owed $32,980. This is the eviction for Nesto, Black Heritage Radio, and all of that. This is Erica's legal work here. Goldberg Sutton LLP. RE notice under OCGA 16-7-21. Criminal trespass warning, invasion of privacy. So this was the letter that she sent to the landlords. Dear Mark and Elena Crow, by way of introduction, this firm represents the managing members of the Black Heritage Radio Association Trust, whom on March 14, 2022, you leased your property to. It has been brought to our attention that criminal trespass and illegal surveillance is being conducted through exploitation of the inspection clause contained in lease. Since the inception of the lease, 3 requests for inspection have been made by Mr. Crow to inspect the premises in accordance with the executed lease. The tenant's representative complied with the first request and was present at the initial inspection occurring on Friday, May 27, 2022. It is my understanding that access to the property was granted, and on that day, the landlord chose not to go past the formal dining room area. A second and third inspection was requested by the landlord to occur on June 8th of 2022 at noon and June 9th, 2022 from 11 a.m. to 1 p.m. The tenant's representative did not consent to the inspection and was not available to meet the landlord at the property due to ongoing health issues. It has been brought to the attention of this law firm that on June 9, 2022, the Mark and Elena Crow came to the property without the consent or agreement of the tenants or their representatives, and both Mark and Elena Crow entered the property and conducted criminal trespass and illegal surveillance under the guise of an inspection. criminal trespass. The events occurring on June 9th, 2022 involved Mark and Elena Crow arriving at the property at approximately 12:04, ending on or about 13:42. The door to the property was unlocked and opened by Crows, despite signage informing landlord that confidential medical records are contained in the property, as the lease is the owner and operator of a business requiring the confidential storage of sensitive medical records. Our client suspects that unauthorized photos, audio, video recording, as well as photographs being taken without their consent. This office is also in possession of photo and video evidence from the tenant security system of Mrs. Crow taking photos of the tenant's license plates as seen below. So remember when Mr. Crow first contacted the police and they said the house had multiple cars in it, multiple vehicles, that they were told to take pictures of the license plate. So apparently they got a security camera and it's showing a picture of her taking pictures of all the license plates that are in the driveway. I would like to advise you and your wife that it is against the law in Georgia to invade the privacy of someone else to record that person without permission. Georgia has passed laws restricting citizens' rights to spy on, survey, and record others. Section 16-11-62 of the Official Code of Georgia makes it unlawful to intentionally record, wiretap, eavesdrop, or conduct surveillance of a person or their personal property without their consent. Breaking this law in the state of Georgia constitutes a felony punishable with up to 5 years in prison and or fine up to $10,000. Georgia also has a special law regarding hidden cameras, which makes it a crime to use a hidden camera or another device to photograph, observe, or record someone else while that person is in a private place away from public view. To lawfully record these activities, the person must gain the consent of all parties in the video or photographs. Violating the hidden camera provision could result in criminal charges and a civil lawsuit. The purpose of this letter is to formally demand that you immediately cease all ongoing criminal trespass and illegal surveillance activity upon the tenants and their personal property, including motor vehicles and professional files and records maintained on the premises. The lease guarantees the tenant's right to quiet enjoyment, and although you are the owners of the property, you cannot infringe on the rights of the tenants. Our clients also indicate that Mrs. Crow has indicated that an eviction has been filed against the tenants. If an eviction is the proper vehicle that you and your wife have decided to take, as the tenant's attorney at law, I am hereby requesting civil process service of said eviction filing. Erica got me nervous, man. She is not new to this. She is true to this. The tenants are now represented by the undersigned counsel, and as such, all communications with them must be directed to undersigned counsel at the contact information below. Please also be advised that there will be no meeting or conferences taking place with the tenants or their representatives without their attorney being present now that litigation is pending. There will be no meeting occurring today at 5 p.m. as I am not available on such short notice to meet with you on their behalf. Instead, please direct all communications to my office, and such conferences will be scheduled with our secretary at time conducive to the attorney's schedule. If you are represented by counsel, please forward your attorney's information to us. Lastly, please provide our office with a copy of your eviction complaint and or email to our office or send via sheriff's entry of service. She might be the best attorney he'd have ever had. And she ain't even. That girl said, dang, Erica studied GIA law like a driver. I'm sitting up here like, should I be looking at these statutes? For some reason, I believe they say what she says they say. Like, I am flabbergasted. I see why she got away with it. I can see why she got away with it because nothing about that would, like, first of all, she uses great, like, she's She's done the letterhead thing. She's been on Canva. She made a letterhead. She got the watermarks. I mean, what about this letter does not look legit? This look like my letterhead. I gotta change my letterhead. I'm like, what? Hey Siri said song. Oh, okay, Siri, I'm sorry. Erica didn't realize the Crows had already spoken to the police by this point. Right. So they probably just took that information and gave it to the police when they got this letter. They probably just forwarded it right to the police. You said them statues might not, but you think somebody really looked those statues up? Usually I look up everything. I'm like, whatever. I look at it in pleadings, because sometimes people do cite and quote statutes in case law that don't say what they say that they say. So I am an avid person, even on people that I know are lawyers, where you look and you're like, you saying it says this, that's adverse to my position. No, I'm going to show that that's not what it says, or it didn't stand for that proposition, or was dicta, which isn't, it's not precedent, or it's not binding law. So it's very interesting. Okay. All right, Erica. Listen. So this is the car for the Mercedes-Benz truck. That's the information. Exhibit UU. There's some hotel receipts. So we must be getting into what pages is 227. So I don't gotta keep scrolling, because we're getting to the end of this document. So let's see. All right, so let's get to item seized directly from the Ford F-350. So this is what we are here for. This is what was seized. The state concedes that certain items of physical evidence found inside the Ford F-350 listed in the defendant's brief would be subject to suppression if the court determines that the Ford F-350 was illegally seized. So the state is saying that if the court does say that the Ford F-350 was illegally seized, they are conceding that some of the items would be suppressed in this case. Those items are the following, none of which is essential to proving any elements of any offense charged in this case. So they're like, the stuff that should be suppressed, if you are to say that this search was unlawful, does not affect our case at all. So they say in the Wells Fargo letter dated April 15th, related to the Bent Creek Manor residence, an affidavit of garnishment related to the Bent Creek Manor. All that stuff was online, because I think we went over that too. It was like paperwork and stuff on Odyssey. 3, paperwork with Miss Gretchen's credit card number. The 4th thing would be hotel room invoices, with the exception of a Hilton Hotels and Resort Hotel folio number 71114A discussed below. 5, a silver and black G-Tech computer. Remember, that's supposed to be where the pictures were. 6, black iPhone found in a black bag. 7 would be a gold iPhone found in the truck. The 8th would be a SanDisk 32 gigabyte USB drive. The 9th would be the vehicle keys, with the exception of any keys found on the defendant's person discussed below. And 10 would be storage unit keys. 11, 2 black toys. 12, black mask with zips and the liquid V. All of those will be suppressed if the court finds that that was an unlawful search. So then they say the remaining items are not subject to suppression. The invoice from the sale of the Mercedes, that's what we just went over, was provided to the state by Ms. Bickham, independent of the search of the 350. The Hilton Hotel and Resorts Hotel was provided to the state by Sonia Durham. Oh, independent of the search. Sonia provided some information too on here. The notice of payment from Palmer Dodge was provided to police by Palmer Dodge, independent of the search. The receipt from Precinct 1 Auto Sales, a copy of the check from Wade Ford and Atlanta Fine Cars contract have not been obtained independent of the search of the F-350, but readily could be, and the state will request that the court allow it the opportunity to do so if the court is inclined to suppress those items. Finally, the black iPhone found on the defendant's person, as well as any vehicle keys or other items found on his person, are not subject to suppression because they were located during a lawful search of the defendant's person incident to arrest and were not from the search of the F-350. The defendant includes 3 additional categories that the state struggles to understand in the context of a motion to suppress. The first category is labeled summary of payments and appears to list of certain payments made by and to unspecified individuals on certain dates. It is unclear if this list refers to evidence seized from the Ford F-350, and the state cannot meaningfully respond. The second category includes a list of arrest warrants. Specifically, they have the different warrant numbers. The state is unfamiliar with any mechanism by which arrest warrants are themselves are somehow subject to the exclusionary rule, and the defendant cites to no support. If it is the defendant's position that the arrest warrant should be dismissed, the argument is rendered moot by the fact that the arrest warrants were long ago served, bound over to the Fulton County Superior Court, and are no longer active. Order of commitment. Moreover, the warrants were dismissed and superseded by a grand jury warrant when this case was indicted. DA declined to prosecute. Okay, grand jury warrant, We'll go over those exhibits. It is unclear whether this list is simply a reference to how certain pieces of evidence tied to charge listed in the indictment, or whether instead the defendant is seeking dismissal of those acts and counts of the indictment. Without more information, the state cannot meaningfully respond. In conclusion, for the reasons set forth above, if the court determines that the F-350 was illegally seized, only the items listed in Section 8 should be suppressed. So, let's go on to the rest of these good exhibits here. Okay. We got the check. We got that. So, Exhibit TT is the Wade Ford document. Exhibit UU is the Hilton receipt that looks like it came from Sonia. That was July 1st of 2022. July 2nd of 2022. July 3rd of 2022. July 4th of 2022. July 5th of 2022. July 6th of 2022. So this is all what, right before he got arrested? Because he got, didn't he get arrested right after that? This is a letter from Palmer about the insufficient funds. This is for the car repair. Palmer Dodge. Affidavit for arrest. Some more search warrants. Redaction. Order of commitment. I think we went over all of that. All right, y'all. I think we have reached we've come to the end. So we have made it to the end of this document. Thank you guys so much for hanging in there. Thank you guys. This was a lot. I'm going to look and see if there's anything I missed or any questions. Hold on. Them text messages were taking me out. Now I got to try to separate some of this because there was one of these that I'll probably do a separate video on tomorrow just to go over this right here, this incident report right here with Delaney. It was just too long. It was just too long to go over. Yes, please hit the like button on your way out of here. We almost been on here for 3 hours. Hopefully it makes up for me not coming on in the last week. I remember that guy wrote a post about Nesta on IG saying he was a scammer years ago. Me too. I wonder what happened to him. I remember that guy as well. When Shirley and Nesto got evicted last time, why didn't they go somewhere together? I don't know. That hotel receipt does not mean he didn't do the crime. The hotel receipt, I don't even get why that's, I don't know. I guess we'll see. I'm sure the state knows why that's important. T in mid-sector says, sorry, Pam, it helped me through a rough, worn day. I'm tired. I'm glad it helped you. I appreciate it. Thank you so much for supporting. So, LC said Diabolical got that woman arrested on a false report. That was true. Erica was about, you listen, Erica studied her craft. That's all I got to say. Thank you so much, Ambi Bambi. I appreciate that. Thank you so much for all of the likes. Andrea, thank you for the super sticker. If you guys send any cash apps, I didn't bring my phone down here. I have to look at it and see. Thank you so much. Nesto's Cologne Flavor Bread said putting my $5 on the documents. Thank you. Forget MLM. They had a MLS multi-layer scamming going on. Thank you, MC, for the super chat. Pam, aren't you glad you changed your phone now? So for those of you that don't know this joke, so when I came outside, apparently, I go in, do my little job, record and all of that. And I came outside to do my live stream. Erica, this was after Erica pled. Erica came outside and I was talking to her. So she was like, hey, can I use your phone? And everybody was in the chat like, no, don't do it. It was like slow motion. Don't do it. She's going to take your identity. I was like, they had me so shook. Because she was real quick to delete the number she called. So I couldn't call back the number that she put in my phone, even if I wanted to. I couldn't do that because she deleted the number out of there. I mean, I wasn't trying to, but I wasn't thinking about I let people use my phone. Y'all was like, oh no. That day I got a whole new phone. I bought a second phone. The intellects had me shook that I was about. Next thing you know, she was gonna be Pam Esquire. And now after listening to all this stuff, that was a lot. But thank you so much for all of the support, and thank you so much for the warnings, because I was a little green, I guess. Erica, if you're here now, when is your documentary coming? I'll be tuning in. Me too, Shining Light. And if she needs some assistance on any legal, matters to put it together, copyright, make sure it's filed properly and nobody steals her intellectual property, I'm here for that too. Thank you for becoming a member, VA Bunny. Bonnie says, sis, you came back with fireworks. Thank you so much. Yes, aka Abuelita, the unmitigated gall of this man. Thank you for the super chat. Thank you, DC Lively, for the super chat. Elsie said, thank you for all you do, Pam. Really appreciate it. I appreciate you, and I appreciate your support. Granny Grace said, I don't even know what to say. Me neither. That was a lot. This was a lot. I'm going to have to go through. This was literally a 2-3 live situation here. It really, really was. The way the evidence that they supported their position was a lot. CCB, thank you for the super chat. Thank you, Miss Buckeye, for the super sticker. Thank you. Thank you, DMV 7811. Thank you so much, Pam. I've been waiting for this. Well, it's here. The passing right. Hopefully it didn't disappoint you. Thank you, Kathy, darling. Thank you for being here. Morky's mom, Patrina. Thank you for the super chat. I appreciate you. What up, though, chocolates? Hey, good to see you. KK Scorpio, thank you so much. Only me. Thank you for becoming a member. Glorious Love, thank you for supporting. Thank you, thank you, thank you. Miss Lazy, thank you so much. The Real Empress, thank you. I think I done. Did I get all of these? I think I've gotten all of these. Okay, y'all. I hope you guys enjoyed the live. It was worth spending $1 quadrillion on these documents because there was a lot going on here. Karen S said this was too good. Thank you for breaking it down. Thank you so much for sticking here for almost 3 hours. 3 hours. I missed you too, Jace. Thank you so much. Are our minds clear? A sister from New Jersey. Thank you for all you do. Thank you for the super chat. I appreciate it. All right, y'all. Our minds clear. Okay, 3 hours. Your girl gotta go eat now. Okay. Girl gotta go eat. I hope I made up for leaving you guys hanging for the last week. Hope you guys can forgive me. I had to get my life together, you know. Yes, I have feeling Chat GPT was Erica Cocon. I agree. But and that's why I said even with Chat GPT, I think that it's good because some people can articulate well. And I think that it's great for formulating sentences and all of that. But as far as law, they do get it wrong a lot. And there have been attorneys, and we even have AI in a lot of our research now. But a lot of attorneys, they have used it and gotten caught up in the game because it's an easy, lazy way. But sometimes the case law doesn't even exist or it doesn't support what they say it's going to support. And so you have to be very, very careful and cautious when you use any type of AI. A lot of AI that I've seen with some of the research I've done, they're not even updated currently on some of the laws. And I'm like, if I would have used this, I would have been judge would have been like, they overturned that 3 years ago. Like, why are you using that as if it's current? So you do have to be very careful. But I agree with you. I do think that she probably used some type of AI assistance. That I agree with. Thank you, Miss HLS. I appreciate that. She said we were more concerned about your health than YouTube. Thank you. I appreciate it. I got it together though, y'all. I got it together. Okay. I will contact you on Instagram, okay? Thank you so much for stopping by. Y'all. I appreciate that. I'm sure you got a story to tell. All right. Yeah, a lot of people have been covering the Jarvis butts. I'll probably go in I think I was in the courthouse when he was there. So yeah, I'll probably go in and do it that way. I got to figure out how to do it because a lot of our local news outlets are streaming it. A lot of the family has been going on live. It's another platform that I'm actually a mod on, and she's done all Michigan local cases. So if you guys saw like the interviews with the family, I was actually over there modding on that day. She does like all of the local Michigan stuff. That's kind of what so I support her when she does it. So I haven't done too many Michigan cases, but yeah, I may go ahead since it seems like it's taking an interest. Yeah, it's taking an interest in a lot of people. I've seen a lot of people do it. So thank you so much. Yes, it was very difficult to listen to. So yes, yes, yes. All right, y'all. Thank you guys so much. I was gonna stay till it was exactly 3 hours. Uh Thank you. We'll be back tomorrow. I'll go over the motion to dismiss tomorrow when I come on to celebrate a few minutes of my birthday with you guys. I come on and go over the motion to dismiss too. So, and I'm going to go over the motion to dismiss because I'm sure Nesto's attorney is going to respond to it. So I don't want to be catching up, having to catch up depending on how long it is. Because it does seem like the state is being way more thorough with their responses. With Nesto's attorney, he's being, he's putting enough in there, but doesn't have a whole lot of meat like the state is having. So utilizing in their documents. So yes, please. I appreciate that. All right, y'all. Anybody else got anything? It's still over 1,000 of y'all in here. You know what I'm saying? I feel like I should be saying something else. I don't know. But thank you guys so much for hanging in there for the last, like I said, almost 3 hours. Thank you, Jana7. I appreciate that. Lisa and Kawana are the realest of all the families I've heard. Yeah, so when you guys see, I think it's community advocates. They were the ones that a lot of people have been using their footage to talk about the family. She set up the family even before the preliminary examination happened. That we all heard was the preliminary examination, to see if they had probable cause to bind them over for trial. That's the hearing that we all heard. In Michigan, we have a preliminary examination, and that's when we determine whether there's probable cause. We don't very rarely have you go before a grand jury like what happens in Georgia with the indictment and unindicted and all of that. Nope, after 14 days you have a probable cause hearing, or you can waive it and bind over, because what can happen oftentimes, which is what happened in Jarvis Butts, is sometimes they can amend the information and they may add more charges. And I think what happened with Jarvis is they were saying she was older, and I guess they found out she was even younger, I guess, when all of this stuff happened. So they amended it and changed the age. If he would have just bounded over, or waived his right to a preliminary examination and just bounded over to felony court, to our criminal justice center, if he would have just bounded over to that court, then we wouldn't have heard any of that. So a lot of people don't even have preliminary examinations. You know, it's a choice. It's basically depending on what your theory is. You know, it's a strategy whether you decide to have it or not. Because again, sometimes when you hold it, then what they will do is add more charges. So sometimes you're like, no, I'll just waive it and go on over there, and then they can do it as charged, and then I'll deal with plea or suppressions or whatever on the other side. So they have preliminary hearings in Georgia, because we had one on the CP charges. We had one on CP charges, but yeah, their system is just ran differently. Happy birthday. Thank you so much for today. I really appreciate this. Thank you, Mrs. CLC. I appreciate that. All right, y'all, I'm out of here. We made it to 3 hours, and I hope you guys again enjoyed the live. And if you missed the live, then welcome to all of you guys that hit the replay. Thank you for all of the super chats. I appreciate that. Again, on the next live, I got in the Cash App file. Shout you out tomorrow when I come back on. But I didn't bring my phone down here, so. But I appreciate you in advance for all of the Cash Apps we receive. But anyway, I'll see you guys in the YouTube streets, probably in the chat, and you guys have a great rest of your day.